Good morning, everybody. We're going to get started in a few minutes with some instructions. So thanks for joining us this morning. Okay, before we turn it over to our first panelist, I just want to briefly introduce the program. My name is Ryan D. Clementi, and I'm a partner and co-chair of Saul Ewing's Consumer Financial Services Litigation and Enforcement Practice. And we're thrilled that you're joining us today for our 6th annual seminar on significant developments in consumer financial services litigation and enforcement. We have a real terrific slate of panelists today, including attorneys from 4 different national law firms, in-house counsel from 3 different consumer financial services companies, and a consultant from one of the leading consumer financial services consulting companies. We have more than 165 registered attendees across the industry, and we're scheduled to provide updates on pro se litigation management, FCRA litigation and enforcement, government investigations and consent orders, and trends in litigation and regulatory enforcement under the TCPA. So before we begin, there's just a few housekeeping announcements. Questions can be submitted through the Q&A tool at the bottom of your screen. We're going to do our best to answer all the questions submitted during the webinar, but excuse me, if we run out of time, we'll follow up with you individually. As far as CLEs, today's program has been approved for 3.5 distance learning CLE credits in Delaware, Florida, Illinois, Minnesota, New Jersey, New York, Pennsylvania, and Rhode Island, with applications pending in California and Virginia. As a CLE provider, we have to be able to verify your attendance. Therefore, at random points during the webinar, we'll display and verbally announce 3 numeric codes that you have to record and report back to us using the CLE survey that you received in your webinar reminder email, and that will open automatically in your browser at the completion of the program. We will in turn send you your certificate of attendance once we receive your survey responses. So just be sure to respond to the Saul Ewing CLE survey with your numeric codes within 5 days of the program. Following the webinar, you'll also receive a follow-up email that includes links to the webinar recording and the supplemental presentation materials. And finally, the provision and receipt of the information in this program is not legal advice, does not create a lawyer-client relationship, although we would be happy to form one with you, and should not be acted on without consulting counsel who have been informed of the specific facts relating to your matter and your issue. And with that, I'm going to turn it over to my partner, Colleen Fox and Kristen Watson from Burr Foreman, who are going to kick off today's festivities.
Morning, everyone. Thanks so much for joining us. Today, we're going to cover a topic near and dear to both Kristen and me, and that's dealing with pro se litigants. So most of the time, these cases are brought because someone's testing a new theory, likely that they found online, and they're trying to clean up their credit. What's interesting is that if you look at the total number of FCRA cases filed in court this year, it's actually slightly down from last year. I will say, though, on the ground, we're not seeing much of a difference at all. I think if anything, we're dealing with a higher volume than ever. And the reason for that is that a lot of these claims are being brought by consumers either in pre-litigation or pre-arbitration demands or right to arbitration. Next slide, please. So here's what we're going to cover today. Number 1, the credit repair boom. As I mentioned, 99% of the time, these claims are brought because someone's trying to clean up their credit. So as I think we all know, consumers are more educated than ever, not just when there's negative information on their credit report, but they know, for example, how much the business filing fee is for the AAA. And a lot of times when we start these arbitrations off, That's what their opening demand will be. This means that there's been a major increase in credit repair companies bringing consumer claims right to arbitration, pre-arbitration demands, or consumers filing pro se, which is what we're going to focus on today. We're seeing the same complaints filed over and over again, literally pulled off of Instagram and TikTok. Pro se litigants are picking up new theories online. Social media is a weird place in this space, guys. Last, we'll look at some examples and talk about lessons that Kristen and I have learned in defending recent cases. Next slide, please.
So just to give you an idea of how this is impacting consumer finance litigation, this is kind of a snapshot of one company's portfolio of cases. And, looking at 2021, pro se filings or filings by non-attorneys comprise about 16% of the litigation portfolio. And just, personally and anecdotally, that seems to be kind of representative of the number of pro se cases or non-attorney cases that I've sort of seen over the last several years. However, in 2022, 2023, filings by pro se or non-attorney representatives comprise almost half of all cases, of all litigation cases being filed. They're typically, start with pre-suit demands or filed in arbitration. But nonetheless, this is having a dramatic impact on how we handle these cases, on litigation strategies. And we have certainly worked to develop new strategies to sort of combat this credit repair boom that we've been seeing in litigation.
Okay, so where do these cases come from? I think if we could go to the next slide. All right, so in getting ready for this presentation and at the expense of permanently messing up my Instagram algorithm, I watched a lot of videos on credit repair on Instagram, and it's really remarkable to me what's out there. So this first one, this is a common strategy that we see quite frequently, actually. It tells consumers to file FTC identity theft reports and list any derogatory accounts that they want removed. And so here's what this post says for those of you who can't see it. If you want to repair your credit, do these 3 steps. You want to get an FTC report on identitytheft.gov. Want to have your ID, your social, and a written statement with the accounts listed that you want removed. Then submit it to the CFPB. Do this every 15 to 30 days until the negative items on your credit report come off. Now, operationally, obviously, this creates a huge burden on you guys when someone illegitimately is claiming fraud and an FTC report comes in and a fraud dispute comes in and it triggers a full-blown fraud investigation. But that's what's out there right now. This next one, so my colleague Rebecca and I had an arbitration against this claimant, and I'll talk in a little bit about how it went. But she wrote a book, which I think is appropriately put in quotes, that Rebecca stealthily ordered on Instagram using a family member's Amazon Prime account. So here's some quotes to give you a sense of the information that our pro se plaintiffs are receiving. In this next chapter, we will look at how lucrative suing CRAs and furnishers can be. These companies are being sued daily and would much rather pay for the loss of these cases than change their internal procedures to fix the problem. And then last, if the original creditor is also reporting on the account, we now have 3 different companies to name in the suit. You can also decide if you'd like to add the CRAs that are reporting as well. Remember, the more companies we sue, the more checks we collect. And then last, this is a very common thing that we've seen online. There's classes out there where a consumer could pay like a couple $100, and they purport to teach consumers, this one in particular, quote, how to make thousands from deletions on their credit report. So these are just samples, guys, of what we've seen on social media, but I will say that this is very much reflected on what we're seeing in litigation in the real world. Next slide.
That's exactly right, Colleen. There are numerous folks out there who run sort of these credit repair services and tend to make a lot of money, it seems, off of educating consumers, selling courses, providing mentorships and things like that. One of the folks that we've kind of come across who seems to be a ringleader and seems to be a source of a lot of these lawsuits and theories and pleadings is a lady named Jen Sanford. This is an image from her website. Her strategy is one round. When she talks about that, that means one round of letters. So as you referenced, Colleen, someone is suggesting you should send complaints in every 15 to 30 days. Well, Jen is trying to alleviate the burden on folks, I suppose, and suggest sending one demand letter. And to encourage folks to try to get a check and try to get money and trade line deletion. Obviously, when the demands are relatively small and, trade line deletion is one of the only demands, it can be tempting, I think, to want to resolve. But I think the problem with that is that you have an entire community of people who are trying to do this, and it's just going to keep encouraging these demands and these arbitrations. I think community is a great way for her to describe it. We actually had the opportunity to depose Jen Sanford earlier this summer. During her deposition, she said that she had over 3,200 people signed up at various points of her website and her classes. So all that to say, this information is being disseminated widely, and a lot of folks are latching onto this to try to clean up their credit and get some money. Next slide, please. So this is just an example of what Jen Sanford offers. This happens to be a free course, and it just outlines how to file an arbitration. She has videos where she walks people through step by step on how to bring claims against companies. She provides theories of liability, and will walk folks through how to do this. She sells a class for $2,000, which she has entitled the Undefeated Arbitration Masterclass. I don't know how accurate that is. I feel like it's not always too hard to combat and defeat a lot of these claims. During her deposition, she let us know that she, I think it's published that she will charge $5,000 for a private mentorship. So while she's not necessarily representing these folks, she'll walk everyone through and provide sort of the guidebook on how to clean up your credit and hopefully get paid. And she said that she had about 40 people signed up. So, I think folks are, especially folks like Jen Sanford, who have businesses dedicated to this. I mean, I think they're making real money, and they're are certainly incentivized to continue doing this. She also has talked about how she's got a team of instructors, folks we have seen both representing consumers and filing their own arbitrations, folks like Azuma Robinson and Brianna Trader, Brendan McAfee, a number of others. So there really is just this network of folks who are proliferating these types of claims. Next slide. So this is, I think, one thing that's really important to note about this sort of community and what is being shared on social media. Settlements are being shared consistently, dollar amounts, communications with attorneys. Even if you have a confidentiality provision in the settlement agreement, it doesn't matter. These settlement figures are going to get shared. I think what's also important to note is that Jen has put together with others what she's called the remedy takeover. And they'll do, as Colleen mentioned, this is all over social media. So they'll do Instagram live videos, and within these conversations, they'll take polls of what companies fight and what companies will settle. One of my favorite descriptors was a certain company was soft as Charmin, and these folks will talk about these companies that are settling and which ones fight. And I think that impacts who they are encouraging folks to send these demand letters to and initiate arbitrations with. So, even though these cases are absolutely a headache, I just think it underscores the importance of pushing back on a lot of these claims, because I think if you're inclined to settle, it's just going to invite more lawsuits, because, like I said, everyone is talking about this and they know exactly who is willing to fight and is willing to settle. Next slide, please.
Okay, so how can you tell that a credit repair company is involved in your arbitration? So I think one of the big ones that we see are these kitchen sink credit disputes that have clearly been copied and pasted from somewhere online. Maybe you've seen them before with another litigant, and they'll dispute everything in the report without any specificity at all. They're not helpful to you in investigating the dispute. That's a very common one. Another one that I think I've seen anecdotally is that the claimant will refuse to talk with you on the phone and will only communicate by email, or they've clearly made a new email address to deal with the case. So here's a pretty obvious example that we actually have seen, and it was first name, last name, credit@outlook.com. So obviously that's not that person's normal email address, or at least I don't think it is. This one's brilliant to me. So Kristen's colleague opened up the properties on a PDF arbitration demand that they received, and was able to figure out that it had been drafted by a credit repair specialist. So what happens is that these people, and we got a question which is absolutely on point, isn't this the unauthorized practice of law? And what these people, and I think the answer is yes, but what these people will purport to do is get a power of attorney on behalf of the consumer that they're representing. And a lot of times they'll just come right out and say it. These people are not shy. So at this point, what we've always done is push back and say, look, we're not going to deal with somebody who's not a lawyer purporting to represent a consumer. We'll only deal with the consumer personally. You know, from an ethical perspective, you need to know you're getting a release from the right person. Non-lawyers don't have the same ethical obligations that we do. There's all kinds of issues with this. So what we'll do is we'll raise it in our initial communications with the representative. You know, if they don't back down, because they do have, which I'll talk about in a minute, a history of getting away with this in the arbitral forums. You know, then if that doesn't work, sometimes we'll send a strongly worded cease and desist. And then last, once you get to the point of having the initial scheduling call with the arbitrator, I've raised the issue with the arbitrator and say, look, we don't think the arbitration should go forward, you know, unless the consumer plans to represent themselves or they get a lawyer to handle the arbitration for them. You know, I think this is textbook unauthorized practice of law, right? I mean, at least in New Jersey, our ethical rules say that representing someone at mediation or arbitration is the practice of law. You know, what's interesting is that the feedback that I know we've gotten from AAA and JAMS is that they don't really care as long as the business pays the filing fee and there's an arbitration agreement in place. They're going to let the case go forward. They've said, you know, you guys could take this up with the state bar. I really do think that this issue will and should come to a head, because it really is, in I think my experience and Kristen's as well, getting kind of. And with AAA and JAMS turning a blind eye, it's not helpful. And I don't know if this looks like industry groups saying, look, if you guys continue to let this go on, like, we're going to pull our business from you. Next slide, please. Okay, so let's talk about some recent cases that we've dealt with. This one is a very common claim that we see. Consumers have latched onto a theory that's floating around online, that it's a breach of contract to report negative credit information without first initiating an arbitration, which, you know, is of course nonsense. It's generally belied by your agreements with consumers. But I'm telling you, these folks are so emboldened by what they read online. Like, there's kind of no reasoning with them, even if you show them a credit card agreement, for example. They're just so convinced that they're right and that this works. So here's what the claim will look like. If there was ever a dispute between us that we could not resolve, it was supposed to be resolved in arbitration. Instead, the bank took action and reported 6 late payments. So this particular consumer brought this claim. She filed 2 separate arbitrations asserting essentially the same exact claim. There were a few words that were different. And what she was trying to do, we think, was she was educated enough to know that our client would have to pay 2 separate filing fees, and she thought that that would force a settlement. So she refused to consolidate the cases when we raised it. The AAA originally kind of deferred to her on that. We wound up filing a motion, got the 2 cases consolidated. And then immediately, by the time we got around to talking to the arbitrator, the first thing you want to do is make sure that you get to the hearing, or better yet, get the arbitration decided on the papers as soon as possible. So in this particular case, we got permission to file a dispositive motion. We responded to the arbitration demand with a counterclaim because she had a significant balance on her account. And the end result was fantastic. We got judgment in our favor on the counterclaim, judgment against her. We actually got costs of arbitration, and we got our attorney's fees as well. So a lot of times what happens too, and what happened in this case, is once it becomes clear to the consumer that you're not going to settle, they kind of back down and stop participating in the arbitration altogether. And I'll just add to, like, this might have been a one-off consumer, but this claim clearly came from somewhere online. And as Kristen mentioned earlier, folks are posting when they get good results. They're meeting and talking about what companies are easy to settle with. So for that reason, I probably wouldn't be overly inclined to resolve these claims. Next slide, please. Okay, so this next case study, this is the credit repair content creator who, just to put her on blast, I guess, her name's Brianna Trader. Kristen mentioned her earlier. So she's a frequent flyer who's an Instagram credit repair specialist. She purports to represent consumers at arbitration. In this particular one, she was pro se. We saw, again, the same breach of contract claim that the client didn't allow her to cure a default before reporting negative information about her account. So again, she was educated enough to know that an in-person arbitration hearing is a headache. And so that's why she insisted that the arbitration take place in person. We learned, meanwhile, she is one of those that post confidential settlement communications with counsel online. A confidentiality agreement means pretty much nothing, frankly. She was posting confidential settlement agreements. We were able, some of them were with attorneys that we work with quite frequently, and we were able to get her to take it down. So here's what we ended up doing. Again, the arbitrator originally kind of capitulated to her request for an in-person hearing. We had another conference with the arbitrator, and we advocated first for a desk arbitration, so an arbitration on the papers. And then we kind of met in the middle on a virtual hearing, which is obviously much less onerous for your business folks to deal with. Once the hearing was virtual and it became clear to the claimant that we were not going to settle, again, she stopped participating in the arbitration altogether. So we got judgment in our favor on this one. And we'll hopefully never hear from this claimant or any of her clients again. Next slide.
So we've had very similar experiences, I think, and it just goes to show that there is really a network, I think, of individuals who are providing information, disseminating information for other consumers to file their own claims, and sometimes it becomes a family affair. We had a series of cases where a mother, a daughter, and a sister all filed arbitrations against different clients within a few weeks of each other. Just as Colleen mentioned, they had this theory that it was kind of a breach of contract to close an account without arbitrating first, which is obviously a nonsense claim. A couple of them amended to add a Fair Credit Billing Act claim. What they had done, they tried, and this kind of, smacks of the sovereign citizen type theory, where they sent in a payment coupon, is what they called it, which was not legal tender, but wrote, UCC provisions and tried to say that the account was paid in full. Sent that in. Clients obviously didn't accept it as payment and continued collecting and sending statements. So they tried to kind of conjure up a Fair Credit Billing Act claim based on that. And if you're kind of scratching your head as to how that constitutes a Fair Credit Billing Act claim, I'm right there with you. It was completely nonsensical, which kind of just goes to show that a lot of these claims are just absolutely meritless. And so even though it's kind of a pain and you're spending money to fight them, they're really quite easy to defend. And I think for all the reasons we already talked about, it just really benefits you to do so. what was kind of incredible to me about this case, and kind of going back to sort of the UPL and sort of the AAA and JAM's stance on non-lawyer representatives, at the scheduling call, when Ashley got on the call, she had a couple of people there with her. As the call progressed, a couple minutes, we kept hearing this chime and someone else would get on the call. And it happened so much that she ended up having 5 representatives with her on this call. And what I really think they were doing, she had folks from sort of this network of credit repair services people who just wanted to sit on calls. I think they do that sometimes. They'll sit in on calls just to kind of see how they go and develop their strategies. Anyway, we raised the issue with the arbitrator. Incredibly, the arbitrator had no problem with Ashley having 5 representatives, but thought that we as licensed lawyers needed to get pro hoc in, which we did. AAA and JAM's rules both say that really you can have anyone represent you that you want, which again, I think back to Colleen, your point earlier about this may be just an industry issue that we need to address, because the AAA and JAM's rules certainly don't trump state, professional, state bar regulations and rules of professional conduct, but that's just kind of the state of where things are right now. Anyway, similarly, we did a documents only arbitration, which I would certainly recommend with these types of claims. Sometimes I'll even have arbitrators get on the call and sort of dictate or say, this seems appropriate for documents only. When I say that, the AAA allows any case that has a jurisdictional threshold of $25,000 or less to be decided on the papers, which we certainly would prefer. I do think, like you said, Colleen, the arbitrators will give pro se claimants a lot of leeway, but I think at the end of the day, they'll tend to get it right. In any event, both Ashley's and Contina's claims were denied, and we were awarded the amount of our counterclaim. I think based on these losses, the sister withdrew her claim, but defeated but not deterred. Ashley actually sued, I think, just out of a reaction, an attorney for defamation. The claim was obviously deemed frivolous, and we were awarded our sanctions. So on top of getting, an award in arbitration, we got sanctions against her for her frivolous defamation claim. So again, I think these can be a headache, but I think it certainly benefits you to push back. Next slide, please. As I mentioned, one strategy is to send cease and desist letters. And I think this is really more beneficial when you're dealing with somebody who is purporting to represent a number of consumers who seem to have sort of a credit service, repair service operation, to try to deter them from bringing claims on other consumers' behalfs. Next slide, please. Another thing to consider, including in these letters, in addition to just sort of citing the general rules of unauthorized practice of law, is that certain states have certain rules and requirements if you're operating a credit repair services organization. Georgia, for instance, prohibits it outright. And so that's something to consider if you're wanting to push back and try to deter folks from bringing claims on others' behalf. And most every other state will require you at least to be registered or licensed, which I think a very few number of people trying to offer these services do. So that's something else to consider if you're trying to deter this conduct. Next slide, please. So Brendan McAfee was one of the folks, he calls himself Pressure the CEO, which is kind of ironic because I think he tended to cave under some pressure that we put on him. But anyway, we sent him a cease and desist letter. As I mentioned, he was one of Jen Sanford's sort of acolytes and had brought a number of arbitrations on other folks' behalf. Undeterred, he kind of doubles down. This was a scenario where we tried to talk to only the consumer, citing the fact that he was not a lawyer and could not represent her. I think also in his communications, he mentions he has a POA, which I have yet to find a state in the country that says a POA, a power of attorney, allows you to represent somebody in litigation, but this is sort of the world in which they're operating. Next slide, please. He continues to belittle us. I think at the time, this was one of the more, I guess, offensive, if you will, things we'd heard. I feel like, we far surpassed the types of communications we get from folks. Anyway, they just will put up a fight. Next slide, please. But ultimately ended up taking his website down. So I think, even if they resist and continue on, I think just keeping the pressure on. I think the most important thing to take away from this is just, have a strategy, stick to it, charge ahead, and continue putting pressure on pro se litigants and their representatives in order to kind of put a stop to this, or at least reduce the number of filings and cases you're seeing. Next slide, please. So I think to that point, it seems like the strategies that Colleen and I have executed seem to help, seem to work. So for instance, here there were 68 cases filed by pro se consumers or non-attorney representatives. Only half of those cases made it to the scheduling call. For the reasons we've kind of cited, a lot of folks will just stop participating. If you show that you're going to not settle, and if you push back on these claims, they just lose interest. I think that the MO is that they send a demand letter, file an arbitration. They think that you'd rather pay them than pay your attorneys and pay the arbitration fees. So when you are unwilling to do that, they don't really have the motivation to continue litigating. I think of these cases, 8 made it to a final award. So really there's a lot of attrition here, and folks will sort of drop off. So I think the point is that I think a good strategy is just to continue putting pressure and pushing back on these claims. Next slide, please.
Okay, so just to summarize, here's some lessons that we've learned in litigating these cases. Number one, assume that any communications, especially communications about settlement, will be posted somewhere online, even if you have a confidentiality clause. Obviously, from our perspective, that's a pretty big disincentive to settle these cases. As far as filings, private arbitration doesn't necessarily mean confidential. If you want to protect the arbitration proceeding itself, see if you can get a confidentiality agreement in place. AAA and JAMS both require the arbitrators themselves to keep the arbitration proceeding confidential, but they don't say anything about the parties, and they kind of leave it up to them. If you do settle, and frankly, I don't know if this would be enforceable, but it could be a disincentive to publish the settlement online. I would think about adding a liquidated damages clause to see if you can dissuade your pro se claimant from violating confidentiality. Next slide. Okay, so the biggest thing to do when a new case comes in, the first thing you want to do is research your pro se opponent. Take a look at their social media, check Pacer, Google them, see if there's any patterns you've seen elsewhere. For example, the breach of contract claim is a very common theory we're seeing right now. I think from our perspective, settlement's a last resort, especially if a credit repair company is involved. Settling a case, and especially paying money to resolve a case, only begets more of these claims. And then last, get to the final hearing as fast as possible. There's generally no need for discovery. Try to get that hearing to be virtual if the claimant's insisting on a hearing, or better yet, on the papers.
Yeah, I agree with all that. And you just want to make sure there are no issues on your end. For instance, if you're pushing back for UPL reasons, you need to make sure that you have folks licensed in the jurisdiction and there aren't any potential problems there. I don't, again, I think it's rare that you want to settle, but if there are issues potentially in your case, that's something to consider. But you just want to make sure that everything's clean, that you don't have mistakes. You don't want to give folks ammunition to take this to their community of credit repair folks and try to encourage others to continue filing lawsuits and make your company or organization a target.
Well, with that said, guys, we are just about out of time. So if you have any questions, we'd be happy to answer them offline. Thanks so much for joining us. And we're going to be joined in a minute by the next panel, which is going to cover FCRA regulatory, enforcement, and litigation updates. Thanks so much.
Thank you.
Great. Thanks, guys. That was terrific and also depressing at the same time, based on our current state of society. So we're going to try to turn things around a little bit. We did have our first code. Our first code was 53113. So go ahead and write that down. Again, it's 53113. So that's the first code that you're going to have to mark down and report back to us. But as Colleen indicated, I'm excited to introduce our next panel, which is going to delve into and geek out on some Fair Credit Reporting Act issues from a regulatory, a supervisory, and a litigation perspective. And I'm thrilled to be joined by really two terrific panelists that we have with us today. First, I'm joined by Badri Sridhar. Badri is a managing director in FTI's Consulting Consumer Financial Services practice. Among many other things, he's an expert in credit furnishing, including Metro 2 format, dispute handling, and standing up quality control processes in these areas. He often partners with outside counsel to assist financial services institutions in operationalizing complex regulatory requirements and preparing for and managing regulatory exams and responding to regulatory findings, including MRAs, PAR letters, and enforcement actions. We're also joined by Marcy Koski. Many of you know Marcy is the chair of Hush Blackwell's Consumer Financial Services practice. Marcy regularly advises companies on compliance with all aspects of the FCRA, including questions and challenges around permissible purposes, pre-screened offers, furnishing and dispute investigations, and she's often called upon to be the FCRA subject matter expert in litigation matters. So we have two really great panelists, and Badri, I think you're going to kick us off, so I'll turn it over to you.
Yeah, thanks, Ryan. Before we dive into all the developments in the credit reporting space, I did want to first talk about what's gone on in the enforcement space and the supervisory space for a little bit. So I think in last July 2022, we did see a groundbreaking enforcement action where the CFPB for the first time mandated customer redress to individuals impacted by credit furnishing errors. We hadn't seen that before. Now, fast forward to last month, we did see the CFPB ask for $150 per inaccurate negative credit marker. And that's another big area that the CFPB is focused on. So we're seeing the increase in the enforcement space as well as supervisory space with credit reporting furnishings becoming a hot button issue for our clients, and we've been keeping us very busy as well. So before we get into all the details of how do we manage exams, what are some best practices in furnishing and disputes processes, I did want to level set everyone's understanding of the credit reporting process. So there's generally three players involved in credit reporting. You have the consumer, you have the data furnisher, which is many of you all on this call, as well, and you also have the CRAs, which the big ones are TransUnion, Experian, and Equifax. The process generally kicks off with the consumer. The consumer submits an application for credit. They submit payments. They're servicing their account. They also submit any disputes directly to the furnisher, and they can also submit disputes indirectly to the CRAs. The data furnisher then takes that information, that payment data and the application data from the furnisher, and transforms that into a standard data format and submits that to the CRAs. So that's generally in the Metro 2 format, but there are other formats that are used for other CRAs. The CRAs then take that data, transform that Metro 2 data or the other credit reporting data into a credit score and a credit report for the consumer. And that goes back to the consumer to review. Now, as you can see from this diagram here, any inaccuracy in this process, whether it's from the furnisher sending in the data to the CRAs or the furnisher responding to a dispute, that inaccuracy can make its way through the entire ecosystem and impact the customer. Next slide, please. So when I work with a lot of furnishers, they ask, okay, where do we start? What's the best place to start when developing a robust credit reporting program? And oftentimes I'll say we'll start with policies and procedures, start with the documentation. A lot of regulations don't have prescriptive guidance on what constitutes reasonable policies and procedures to comply with the regulation. But with FCRA, you do have prescriptive requirements per FCRA, and that's covered under Appendix E. Now, there are 13 components for Appendix E, A through M. And if you could, Ryan, quickly flip to the next slide. You might flip back, though. So this illustrates what Appendix Appendix E items A to M cover. So you have system furnishing consumer information, covering data, reporting standard data formats, record retention, having appropriate internal controls, just training, oversight over your service providers. So there's a lot of different areas that Appendix E covers, and the CFPB will expect that a reasonable set of policies and procedures cover all these areas. A very effective way to look holistically at your policies and procedures is to take all your policies and procedures for FCRA, map them to Appendix A through M, and see where your gaps are. Now, this is just an illustrative example of holistically how you could look at your policy and procedures and how they map to Appendix A through M and see where you have some gaps that need addressing. And Ron, if you don't mind going back to the next slide, previous slide. Yeah, thank you. So once you have a good set of policy and procedures, it's also very important, if not just as important, to make sure they're being followed and adhered to. So it's one thing to have the document policies and procedures that are approved by your legal team, your compliance team, but then your staff should also, your operations should also align to those policies and procedures. One effective way to check for this is to review job aids, review any informal documentation, and sit down side by side and review processes, confirm everything lines up there. Then also, what we also recommend is considering maintaining an end-to-end business requirements document on all your credit reporting logic, all your furnishing logic, all your business rules. So I think Ryan and Marcy could probably say this better than I can, but the credit reporting guide is just a guide. It's not law. So you should sometimes deviate from this guide, and based on your business practices and your system limitations or system capabilities, you may have different ways to interpret the guidance. So that should all be documented in a BRD. One area I've seen, at least lately, with some furnishers is they implement a new servicing system and they may hand the Metro 2 guide to the coding team. And then when the guide has a lot of room for interpretation, so that can cause some downstream impacts where there could be some furnishing inaccuracies and a misalignment of expectations on how you all are furnishing. So documenting the BRD is something we definitely recommend for all credit reporting rules and logic. So moving on to, I guess, slide 26 here. So quality control of the furnishing file. So this is another key area we want to highlight. So I know Ryan's going to talk about litigation and Marshall will talk about some upcoming credit reporting guidance coming out, but I think it all starts with quality control of the furnishing file. And one area that CFPB has called out in recent enforcement actions is the pre-submission quality control. So there's a range of third-party tools available. We have a tool, other great vendors have a tool as well, but there's a way to look at the full furnishing file, identify illogical conditions. So for example, if your account is reporting as current, but has an amount past due, one of those two fields is incorrect, or maybe both of those two fields are incorrect. So those fields, those are trade lines with those inaccurate or illogical conditions should be suppressed, and then the file can be sent out. This was called out in a recent enforcement action by the CFPB and something they do look at during examinations. It's also a very effective way to perform quality control on all records furnished. In addition to pre-submission quality control, we do recommend post-submission quality control. So after the submission, performing periodic reviews of a targeted sample of accounts. And what we do recommend there is you have your reject reports, you have customer complaints, you have disputes, you have your pre-submission quality control results. You can take those results, look at for the high-risk areas. So for example, if you have an uptick in disputes or complaints in the payment history profile for certain areas like bankruptcy or deferrals, sample accounts from those areas, and then do root cause analysis and take data from your system of record, manually recalculate the data compared to your Metro 2 file, and then taking a step further, compare it to soft pulls. So that way you can see if there's any break in the process from the system of record to the Metro 2 to finally the transformation the CRAs undertake to transform that into their credit report. So this can be a very effective way to identify any issues that require remediation, either system issues, or it could be training issues if there's any manual updates or intervention on the trade lines. For all these areas, we do recommend root cause analysis to be performed. So that requires working with key stakeholders, SMEs and credit reporting, your data teams, legal, compliance, just to identify the nature of the issue. And as you learn more, these issues do evolve. We find when doing root cause analysis, you may have to revisit the root cause analysis, and it may actually, an issue that you thought impacted 1,000 accounts may actually impact 10,000 accounts. So that narrative and that root cause analysis should be revisited, and just so everyone is on the same page of what the issue is, because remediation can look very different if it's 1,000 accounts versus, say, 10,000 accounts. Next slide here. So switching gears a bit from furnishing to disputes. So one area CFPB does focus on is obviously your disputes, your complaints. 60% of all the CFPB complaints are credit reporting related. So it's very important to have robust processes on how these are tracked, routed, investigated, and ultimately responded to. Now with indirect disputes, generally if you use eOscar, there's a tool called Insights by eOscar. You can use that tool to analyze your disputes, analyze what your customers are disputing, analyze the volumes, the trends. But with direct disputes and complaints, there's no structured data format that those come in. Depending on your intake channels, they can look very different. So it's good to have set robust processes so you can easily identify your direct disputes, similar to your indirect disputes, and differentiate them from complaints. That way, if a regulator or any third party asks, show me all your disputes related to a certain area, you can easily and quickly produce those records. And we see many furnishers struggle with producing that data and maintaining and tracking that data over time. In addition, there is what we find there is a seasonality component with disputes and complaints. So it's good to review periodically your staffing levels for handling them. So, and how the reasonable investigations process is performed. There's guardrails, but furnishers can define their own reasonable investigation process. So important that you have the right tools in place to perform the reasonable investigation per your policy and procedures, as well as the right number of FTEs to appropriately and accurately respond to disputes within statutory timelines and meet your SLAs. In addition, there also should be monitoring of your disputes and complaints, including the frequency. There should be a sampling methodology and procedures and escalation triggers if there are an uptick in exceptions for disputes. It could mean that there needs to be a training refresh, or there needs to be some updates to tools that are used for responding to disputes, or there could be just an issue with the individuals and the data they're looking at. So that should also be investigated as well. One red flag I find with disputes monitoring is if there are no findings month over month. This is a very manual process. Mistakes do happen. There's a lot of manual keying generally into the eOscar system. Like for example, the payment history field in eOscar, it's about 84 bytes of information. So individuals are manually keying that information in, and there will be issues, right? So if the quality control processes are not finding any exceptions, I think that means there's either there's an issue with the sampling methodology, or maybe the process for monitoring the disputes themselves. They may not be doing an end-to-end reinvestigation of that dispute. Next slide here. So change management, I think we're running up on time, so for this section, so I won't spend too much time on change management, but high level, furnishers should engage early and often with their key stakeholders. So people in the legal team, understanding what enforcement actions have come down and what the impact is to their processes, such as pre-submission quality control. Many furnishers, after that recent consent order, identified a need to incorporate pre-submission quality control based on the CFPB's guidance. That's one key area. The CARES Act, that was another area that a lot of furnishers struggle with. They're working remotely, they had new guidance and ever-changing guidance day over day, and they had a hard time working with their key stakeholders to implement these updates to their processes, systems, people, and technology. So we do recommend that a robust change management process take place and is implemented.
And Badra, you've gotten really deep into furnishers data and furnishers policies and procedures. Like, can you just talk a little bit about what problems you're seeing across the board for both on the data side, and also what blind spots you're seeing with furnishers policies and procedures as you guys are getting into them?
No, that's a great question. I think I'll start with policy and procedures. So one area that I find when reviewing policy and procedures is a misalignment with what the policy and procedures say and what's actually the actual practice of the furnisher. So, for example, I was talking to a furnisher recently and reviewing their policy and procedures. They had a single intake channel for direct disputes. Generally, that's a really great practice. You have a single PO box. The disputes come in. The mailroom knows those are disputes. We open the mail. We scan it in. They give it to the disputes team to perform the reasonable investigation and track the disputes and route them to appropriate teams. The only problem was when we talked to the actual staff, they were taking disputes over the phone. They were taking them via email, fax. They were also taking them via the branch, which is very problematic because they weren't necessarily being routed to the right teams for review. They weren't necessarily being tracked in the right system. And that was causing an issue for them, and they had to button that up because there's a misalignment between their procedures as well as with their processes. So that's one issue we see with policy and procedures. In terms of data, oh boy, there's a lot of things I have seen with data, but generally we see a lot of issues with the payment history profile, especially for cycle reporters versus month-end reporters, but we see it with both just because it's such a complex field. There's a lot of different things coming in upstream from credit reporting, which impact that payment history profile field. And it's essentially 84 fields in one, because you're looking at the account status over the last 84-month period. And we're seeing a lot of issues there. And generally for the system upgrades, there's no silver bullet. If you upgrade your system, you have to make sure your business requirements and system requirements are all aligned with your business requirements.
Yeah, payment history profile is a big one. I mean, I'm sure Marcy can speak to this too, but for me, that's one that creates all kinds of problems on the litigation side. It's probably one of the leading indicators for litigation that's creating litigation. The other one that I want to just comment on briefly, we're going to talk a little bit about ID theft and fraud, which is one of my topics, but also bankruptcy. I mean, bankruptcy is incredibly complex, right? And it's creating all kinds of problems for clients in terms of their reporting. I mean, you have to change the reporting based on the status of the bankruptcy, and you have to insert certain codes at various points. So it is incredibly complicated. And I keep seeing furnishers and clients of ours, kind of get sideways with the reporting on the bankruptcy side.
Yeah,
no,
I couldn't agree more. In fact, when Ryan, Badri, and I were preparing for this, we were talking about how the CRAs are under some immense litigation pressure for post-discharge reporting, which of course rolls downhill to furnishers or uphill, however you want to look at it, and just causes so many complications and is really ripe for litigation against furnishers as well.
And a lot of furnishers have decided, okay, it's not worth the risk. Let's just delete any account in any bankruptcy status. Well, then how do you document that process? So that goes back to the BRD. Document the fact that you are not furnishing any bankruptcy status. You are deleting them, and your dispute should be aligned as well. You get a dispute in, it's in a bankruptcy status. Maybe your response should be delete in that case. And that's
Badri, how do you feel about that and like the integrity of the credit reporting system, the deletion of those types of trade lines?
Yeah, that's a great question. I know the CRAs don't necessarily like it. It's data. It's good data sometimes. They don't like the deletion. But if institutions don't have the right systems in place to accurately furnish bankruptcy data in a timely fashion with the right status, I think the only option is delete. And deletion isn't inaccurate reporting. That's why deletion is an option. And I think furnishers should look into deleting those trade lines if the other option, if they don't have a viable option for reporting bankruptcy accurately. So I think it's a good approach, but CRAs don't necessarily like it, but there's not really much they can do. And it's better than furnishing inaccurate information to the system.
Yeah, and before we move on, I just want to make one other comment on kind of the front end process and the dispute process. Clients ask me all the time, like, we're getting inundated with FCRA litigation. What's the best way to avoid FCRA litigation? Do all the things that Badri just talked about, to be honest. I mean, look at your QC of the data that's going out, quality control your data as it's being furnished, and make sure that there aren't any logical inconsistencies in the data, but also make sure you have really strong dispute policies and procedures, right? So you have an opportunity pre-litigation to address these claims before they ever get filed. And that's in the dispute process. And if you handle them properly in the dispute process, you can avoid a lot of litigation downstream. So for everything that Badri just talked about, I can't emphasize enough from a litigation perspective how important that is. So.
But everything that you can possibly do still will not avoid people making claims, right?
Well, yeah, I mean, we just heard from Colleen and Kristen, right? Like there are people effectively manufacturing these claims online and trying to create a cottage industry over it. So you're absolutely right. Absolutely right. Marcy, you want to talk a little bit about some of the regulations and the changes that are coming down?
Yes, you bet. Are you done?
Well, we can come back to this if there's time, because I think we're running a little over. So Marcy, why don't you go ahead?
Okay, great.
But
can you flip through to whoever's controlling the?
Yep.
Thank you. Okay. Excellent. All right. Well, I am going to chat with you all today about a proposal that the CFPB, our very aggressive CFPB, is considering. And that relates to amending the Fair Credit Reporting Act. Many of you may have seen this, the news, the pronouncement by the CFPB, but it's really being pushed out as a change that would impact data brokers. Well, I'm here to tell you today that it would impact the entire credit reporting ecosystem, would not just impact data brokers. Speaking of which, what is a data broker? Well, there's no, to my knowledge, anyone can correct me if you know otherwise, but to my knowledge, there's no specific definition of a data broker in any applicable law that we deal with on a regular basis. Here, the CFPB so let me back up. What the CFPB has issued is a SBREFA outline for considerations of amending the Fair Credit Reporting Act or the implementing regulations. And in this outline, they attempt to define what a data broker is, and it is very, very broad. And then in turn, what the CFPB is telegraphing its intent to, in turn, very broadly define consumer report and consumer reporting agency. If I can get to the next slide, please. All right, so let's start with basically what the definitions in the Fair Credit Reporting Act say. So in the statute, the two definitions of the definition of consumer report and the definition of consumer reporting agency, very broad, and they interact with each other. So it's very circular. First, the definition of consumer report. So a consumer report, there's two elements. First, the information contained in the report must have a bearing on one or more specified consumer characteristics. For example, creditworthiness, mode of living, several different specified characteristics that are quite broad. And the second element is the report must be used or expected to be used in whole or in part to determine eligibility for consumer credit, as relevant here. Of course, there's other reasons too, for example, insurance. For consumer reporting agency, there are three basic elements of consumer reporting agency definition. There's actually four, but that's an interstate commerce element, which in most cases, given the broad meaning of interstate commerce, would be met. So to be a consumer reporting agency, a person must, one, for monetary fees, dues, or on a non-cooperative basis, regularly engages in whole or in part in the practice of assembling or evaluating consumer credit information or other information on consumers, and three, for the purpose of furnishing consumer reports to third parties. So the Fair Credit Reporting Act, just to think about it holistically, really originally was a privacy law, and it was intended to protect the distribution of PII willy-nilly and to allow a consumer a mechanism to correct incorrect information. But nevertheless, the statutory words, of course, have meaning. And when we're going through an exercise of, okay, would this particular fact pattern make this type of information a consumer report, we look at these elements. When we're considering whether an act that a person or entity intends to do we look at the element of what is a consumer reporting agency to determine and discern whether that activity would make the person a consumer reporting act. Here, the proposal by the CFPB turns all of this on its head. It would read out eligibility for credit. It would read out the purpose for which that consumer report information is used. Next slide, please. Most importantly, or I think one of the biggest issues with this proposal is that the CFPB would interpret or define credit header data as data that is consumer report information. So credit header data for years has been considered not to be consumer report information. Back in the early 2000s, there was litigation when the GLBA was enacted, and it questioned whether credit header data, which is biographical information, name, address, social security number, phone number, if that information is consumer report information. And when that question, in the context of the GLBA, went up to the DC Circuit Court of Appeals, the DC Circuit Court of Appeals said no. Credit header information is not consumer report information. That was consistent with the FTC when it was in charge of enforcing FCRA before the CFPB came into existence. The FTC itself had concluded in an opinion regarding an action with TransUnion that credit header data was not consumer report information unless, quote, such terms are given an impermissibly broad reading. Another court, just to pile on here, is to all these smart judges and agencies looking at this question. Another court, this in Massachusetts, less than 10 years ago, also expressly sanctioned the use of credit header data to perform identity verification without it being considered a consumer report. Because according to that court, the accuracy of a social security number did not bear on a plaintiff's credit worthiness. However, under the CFPB proposal, credit header data would be considered consumer report information. And the CFPB says, well, yeah, you know, and the CFPB doesn't quite expressly refer to what has happened in the past, but they make a statement that, well, as companies have amassed more data and more information, credit header data is being used for eligibility determinations. The Consumer Bankers Association and maybe others have sent letters saying, hey, this is a problem when it comes to identity theft. So many of you in the audience may be using identity theft tools, especially in your online flows of originating credit. That service that you're using may be relying on credit header data. So were this outline of proposals in the manner in which it is currently fashioned became a regulation, the use of credit header data would be considered a consumer report. In turn, if you're using credit header data to consider to confirm somebody's identity, you're not able to confirm identity, that would then kick in, right, your responsibilities under FCRA. This is, in my opinion, this is, while I think the outline of proposals to be considered, all of it is pretty, maybe you could call it a little earth shattering. This one is a really big deal. Next slide, please. So under the Fair Credit Reporting Act currently, and you know, since it was enacted, setting aside pre-screened, the general rule is that consumer report information cannot be used for marketing purposes. And just as a level setting measure, right, if you get a consumer report for a permissible purpose, somebody comes to you, they apply for credit, you have a permissible purpose to obtain that person's consumer report. You can't then use that consumer report information subsequently for marketing purposes that you obtained from the CRA. So keep in mind that even though you get a consumer report for a permissible purpose, be careful of how you use that consumer report. Here, the proposal being considered consistent with the general restriction that you cannot use consumer report information for marketing purposes, but it goes a step further and says that aggregated or anonymized data that doesn't specify a consumer, that would be information that could not be shared by a consumer reporting agency or a non-CRA without it triggering FCRA responsibilities. And the question there is, okay, so we're going back to the reason why FCRA was enacted, privacy of consumer information. But if there's information that's aggregated or anonymized, that to me does not bear on an individual and certainly doesn't implicate the policy purposes of FCRA, nor does it implicate the plain language of the statute. Next slide, please. All right, so we talked a little bit about permissible purpose, and the CFPB considers permissible purpose in its outline. And one aspect of the outline suggests that the CFPB will prescribe prescriptive regulations that require a user of consumer reported information to obtain a specific kind of written consent. So currently, there is no rule implementing the written authorization permissible purpose under the Fair Credit Reporting Act, but the 40 years has given us some guidance. So when the FTC, when the CFPB took over enforcement of FCRA from FTC, the FTC issued a really helpful guide called the 40 Years of Credit Reporting. And in that 40 years, the FTC gave guidance that said if a consumer is giving written authorization, they have to be specific. So, and the specificity would be, I authorize you to procure a consumer report on me. That was the example given. That to the FTC was sufficient. In contrast, something that would say, I understand that where appropriate, credit bureau reports may be obtained was not specific enough and would not be sufficient consent. Here, the CFPB telegraphs that it may be considering prescribing specifically how a user may obtain written authorization, how downstream parties can rely on that consent. They may consider some temporal limitations, how that consent is obtained, electronic, check the box, etc. Given the recent FCC pronouncement yesterday on TCPA, a lot of this seems to sound sort of familiar.
Hey, Marcy, there's a question I just want to pose that was put in the Q&A is, will the sale of leads based on aggregated data now be illegal under the CFPB guidance?
Well, just as a reminder, this is just an outline for consideration, right? So there are additional steps that need to be taken for this to be promulgated and it to be effective. And then even then, I assume that there's going to be challenges to the rule. So this is far down the road. That said, if you're trying to read tea leaves and you're trying to be as compliant as possible, this certainly telegraphs to us what sort of mindset the CFPB has on various things. To answer this specific question, will the sale of leads based on aggregated data now be illegal under CFPB guidelines? I don't think they'll be illegal, but I think they could very well implicate the Fair Credit Reporting Act, making that seller of leads a consumer reporting agency, and then triggering obligations imposed on them as to when and how they can share that information, and requiring somebody who wants to buy those leads to have a permissible purpose. In that situation, right, if a consumer is not initiating it, the only way that there would be a permissible purpose would be a pre-screened offer. So you get that information, and then you have to make a firm offer of credit using that information. So
Yeah, I think it'll open up potential liability for people who are doing that if you're not following the prescriptions and the prohibitions in the FCRA, right? If all of this comes to fruition. But how do you see, Marcy, this applying? I mean, a lot of our clients are really furnishers, right? And a lot of folks that are attending to, how do you see this impacting furnishers, if at all?
Yeah. Oh, it's definitely going to impact furnishers. First, the identity theft that I just mentioned. Second, the proposal also would prohibit. So currently, CRAs may not share consumer information with third parties. They might house that information and then use it to advertise or take other actions on behalf of furnishers, but they're not sharing that information. And one key element to be considered a consumer report or consumer reporting agency is that there's, a distribution of that information. The CFPB says we don't care about that. Even though you're not sharing that information, if you're undertaking efforts on behalf of the lender, that would still be activity that is subject to the Fair Credit Reporting Act. So entities that are relying on CRAs doing that kind of activity, that would be something that could no longer take place. Those are, and then the credit header data, identity theft. Furnishers would be subject. Oh, and I guess if you think about it too, like any vendor contract that you have right now where you are agreeing that you're not using it for eligibility and you're agreeing that that third-party vendor is not a consumer reporting agency, I think that turns it on its head too. And Ryan, I know we only have very little time left, so.
Yeah, but I also, I noticed that one of the things that I noted as a litigator was the potential to dispute, consumers to dispute or on a mass basis or a class basis. So in effect, they're submitting a mass or a class dispute. Is that, can you talk about that for a moment? Because to me, when I think about it, furnishing clients have enough difficulty trying to respond to a single dispute. And the thought that a consumer can submit a mass or a class dispute is mind-blowing to me.
Yes, and it should be mind-blowing. So under the proposal, the CFPB is considering whether to provide a rubric or a template that consumers can use to submit disputes relating to what they believe is a systemic issue affecting multiple consumers. And then in turn, the CFPB is also considering whether to require furnishers and CRAs, if as part of an investigation, they determine it's a systemic issue, then whether and how they should notify affected consumers, which is mind-blowing and not consistent with the statute at all whatsoever. And in my view is FCRA already solves for those problems, right? Like a furnisher cannot report inaccurate information. If they realize there's a systemic issue, they need to be fixing that, right?
Yeah.
So.
And one of the things that concerned me if this were to be put into law is the fact that, FCRA cases traditionally have been annoying, right, to clients because there's so many of them. But what they aren't and what they haven't been under 1681 is class action risk, right? And so the thought, I wonder how this could impact the class action risk under the FCRA if this is put into law by allowing you to submit a class or a mass dispute. And then would you have the ability to sue under 1681 if that mass or class dispute wasn't responded to appropriately? So to me, I think that's a really significant potential change coming down the pike. But yeah, I think we got about 5 minutes left. So can we fast forward to the litigation update, and I'll go through this pretty quickly. Marcy, was there anything else that you wanted to cover on that potential rule before we jump to kind of the litigation side of things?
Go ahead.
Yeah. So, for those of you who joined this panel previously and participated in the CLE, you've heard me talk for the past 5 years about the increase in these cases. We've seen it anecdotally in the portfolios that we manage year over year over year for at least the past 6 or 7 years. FCRA litigation has continued to trend upward. But I am here with some good news this year because it seems like we are finally leveling off. So according to Web Recon Stats, which tracks the litigation filing trends, FCRA litigation has declined by about 2.1% over last year. And just from our own perspective, these cases still make up a majority of our clients' litigation portfolios, or a very significant portion, but we don't appear to be seeing the increase that we have in the past. But I do want to put an important asterisk on that optimistic outlook, which is those figures only represent filings. And we heard from both Kristen and Colleen this morning that what we are seeing are more pro se disputes in arbitration and more credit repair disputes being submitted. So it seems like consumers are taking matters into their own hands, and it may not necessarily be coming in the form of actual filings. It still remains a really central focus of state and federal regulators. So that's something that Badri already mentioned earlier today, and we're not going to cover any of the consent orders that have been entered. But one additional trend that we're seeing in real time and we're dealing with is the difficulty that we're having in resolving these at the early stage. So for anyone who litigates these cases, you know that what traditionally in the past you've been able to do is get out ahead of them early, cut them off, identify bad facts that may be in the credit file or in the review history, and try to resolve these pre-discovery, right? That's been a really essential focus for how we've dealt with these claims. We've also seen these claims resolve on high four figures, low five figures. But now what we've seen more so this year than we ever have in the past is plaintiffs' counsel who are unwilling to even discuss settlement at an early stage. They want to get into discovery, which is problematic because most of our clients really want to resolve these cases early. And if you get into discovery, it's oftentimes, particularly if you're dealing with an ID theft claim, there may be things in the file that are really problematic and are going to make settlement difficult. The other thing that we're seeing and we're receiving is six-figure demands at the outset. If we do get them, they're really, really high demands. What I think is happening is I think the plaintiff's bar is trying to push up the median average of these cases, right? So what used to be a $12,000 or $15,000 settlement, what we're seeing is they're trying to move the bar upward. They're trying to say that average FCRA cases are now more valued at between 25 and 50, or the average they want to see for a misreporting of a late maybe $50,000 because of the emotional distress and harm that was allegedly caused. So it's becoming more and more difficult. I want to pause for a second. Marcy, you're involved in a lot of litigation and your firm handles a lot of these cases too. Are you guys seeing similar anecdotal evidence of any of those things?
Yeah, absolutely. And particularly, right, this idea we're not gonna settle. We've even sent out some offers of judgment where things are a little prickly and no response, zero response.
Yep.
So.
Yep. And those are just two options, right? So as Marcy mentioned, one of the things that we're doing more than we ever have in the past is considering offers of judgment, right? You're trying to manufacture some risk for the plaintiff side if they are going forward. So that's something that we're trying to do. The other thing is if you have an arbitration provision, these are the types of cases that you should really consider utilizing your arbitration and moving to compel, because some of those soft damages that a jury may consider, such as emotional distress and harm, I think are a lot less risky if you're before an arbitrator. So that's something that we're utilizing more in the past. Next slide. Go ahead and continue to the next slide as well, since and just one more. So I want to just talk briefly about ID theft claims. This is an area that clients continue to get tripped up on. How we try to resolve these claims and get at them early is we try to ferret out the bad facts that may be in the file to show an indicia of fraud. Those are the cases that you're really going to want to try to get at early. You're going to want to likewise identify facts that may support the review. So check call logs, call recordings. Yes, call recordings are important to pull. We determine where the statements are being sent. We use third-party resources such as Accurate and People Map search to see what addresses and telephone numbers may tie back to the plaintiffs. Just a few weeks ago, I think it's important for me to note that I had a client flag the submission of a fraudulent driver's license, a manufactured driver's license that was submitted as part of a fraud dispute and in an attempt by a consumer to get the account written off as fraud. I highlight that because that's the level of sophistication that some of these consumers are operating at, literally manufacturing fraudulent driver's licenses in order to help get rid of negative account reporting. It's important for you and your teams to be routinely trained on best practices going forward to, find out kind of what's coming down the pike. Next slide. So we have our second code. So I'm just going to pause for a second. That's 79432, 79432. So please be sure to write that down and report that back to us. So another issue with ID theft that I do want to highlight quickly is we're seeing clients using an incorrect standard being applied to this game. So Badri kind of touched on this, which is it's great to have written policies and procedures that track the law, but it's really about how you're implementing them. So this year I had more than one client say to us, we affirmed or reaffirmed the account information as belonging to the consumer because the consumer didn't prove fraud. The consumer didn't prove fraud, but that's not the law and that's not the standard. Instead, the FCRA states that if an item that's disputed by the consumer is found to be inaccurate, incomplete, or cannot be verified, then the furnisher's obligation is to modify, delete, or suppress. The standard doesn't place the burden on the consumer. Rather, it places the burden on the furnisher to verify the information as belonging to the consumer and the account as belonging to the consumer. And that's how your written policies and procedures should be written and how they should be implemented. The CFPB is keenly aware of this issue because they've submitted amicus briefs in a Third Circuit case this year on this very point about a furnisher using the wrong standard. I usually say it this way, right? Which is if there's an indicia of fraud that can't be explained or a consumer's identity that can't be verified, the furnisher's obligation is to delete. Can we go ahead and go to the last slide? Okay, so this, I know we're over time, but I think this is really important and I want to get Marcy and Badri's comments on this too. So what could be next on the horizon? We've had a few clients flag this issue for us this year, and I've seen a few clients struggle with it. So we are aware of at least one CRA, TransUnion, that is sending written communications to furnishers, advising them that a fraudulent application was submitted without consent. TransUnion then directs the furnisher to check your records and notify the consumer of the results. This is completely outside of the electronic process, right? It's not being submitted through eOscar. These are written letters. So certain clients have been confused about what to do. I'm just going to say from my perspective, the answer is don't sit on your hands. You have to do something, right? And I think when you have to undertake some investigation here. I think that both the CRAs and your regulators are going to expect you to respond, not necessarily to the CRAs, but to take action in investigating whether or not you can tie these inquiries to either an account or a legitimate claim. So a legitimate inquiry from a consumer. So I'm going to pause real quick and give Marcy and Badri an opportunity to talk on this.
Yeah. Marcy, go ahead if you want to start.
Yeah, well, I'm just gonna say it's fascinating. This is fascinating, right? Because the FCRA does not contemplate, one, this process, as you point out, Ryan, but two, it doesn't contemplate damages for it, right? And we were in prep for this call, we were talking about that, like looking through the damage and the remedies, and it just doesn't contemplate this as an issue whatsoever. So I agree with you, Ryan, that, the answer is don't do nothing. Right. And the better, I think, approach is have a process and policy in place. And with that, I think that's probably a natural segue to what Badri was going to say.
Yeah, no, thanks, Marcy. And I agree with both Ryan and Marcy. You simply can't do nothing with these. But what do you do with them, right? So yeah, it's definitely, you have to update your procedures, update your job aid, update your training, update how you're intaking these letters that are coming in and becoming more prominent in the furnishing industry. But then also, how do you know what you did in the past? So it involves tracking, right? So how are you tracking these? So you get let's just say 20 a month over a 7-year period. Like, how are you tracking how you responded to each one of these? Because CFP may ask, how did you respond to this letter from your CRA? And if you don't have a good tracking mechanism, you don't have a good way to produce these records and produce how you track them, that can put you in a very bad position.
Yeah, and I think when you're writing the policies and procedures, be careful not to characterize it, at least I wouldn't characterize it as a fraud dispute. Because if it's fraud or a claim of fraud, it may have an impact on how you're reporting that account if it actually made its way into an account. And the other thing to be careful of is I wouldn't even call it a dispute, because I wouldn't want it tied to 1681 that could suggest it is an indirect dispute or a direct dispute in some way that could either trigger regulatory action or a private right of action by a consumer. So this is definitely something that I'm going to be monitoring going forward. We expect and we understand that the other CRAs are likely going to be coming up with similar policies and procedures where they're going to be issuing these letters or some other communication that you're going to have to respond to. So keep an eye on this. Certainly see it as an emerging issue. Guys, anything else to add? I know we're a little over time, but anything else to add?
I think we touched on a lot. I know we're over time, but I think just one thing I think touched on this briefly, Ryan. There's clients often ask, okay, what do we do? How do we fix our furnishing? There's no silver bullet, right? It's not a new system. It's not a new policy and procedures. It's really everything we covered today. Quality control, building robust processes, making sure your policy aligns to your policy and procedures. Always asking your teams the tough questions, like why don't we have any exceptions this month? Why are the exceptions up this month? Can we dig a little deeper, figure out if there's a more prominent issue that's just underlying these results? So I think this is everything we covered and that's bottom line, no silver bullet.
That's great. Thanks, guys. We're on a break now. We'll be back on until 10:30. The next panel will pick up. But thank you, guys. That was really terrific. So thanks.
Thanks, Ryan. Thanks, Badri. Thanks, everyone. Have a great
Thanks,
day.
everyone.
All right, welcome back, everyone. Now we're going to do the government investigations with me, Jason McElroy, and Trip Riley.
All right, everybody. Again, thanks for joining us. We're going to kick this off now. And Jason, why don't you take the next slide?
Great, thanks, Trip. So we're going to be going through a lot of stuff in a fairly short period of time today. So the majority of actions that we're going to cover today have actually occurred since this past summer. Many in the last few weeks. There's been so much going on that we'd probably need a full day just to cover the things that have happened since I sent my daughter off to summer camp in July. So there may be a few things that have happened that we may not cover today. Reach out to us, let us know if you want to talk about any of those things. But we're focusing primarily on the consent orders and the actions that have been taken since the end of this summer. So even in the last week, these agencies have been pretty busy. The FTC just issued its CARS rule addressing misrepresentations in advertising and junk fees in the automotive industry. And the CFPB argued its appeal in the Townstone financial matter last Friday in the Seventh Circuit, which addresses the redlining theory that the CFPB has brought under ECOA. We're going to talk about the redlining issues really more than the Townstone issue today. But that Townstone appeal was actually, it's interesting to listen to. The oral arguments available on the Seventh Circuit's website. Reach out if you want a link to it. But the CFPB, the FTC, the DOJ, the Department of Education, state AGs, all of these entities have been active just in this time period since the end of the summer. Recent press reports that you may have seen have noted the CFPB intends to increase its enforcement staff by 50%. I'm going to let that sink in for a second and repeat it. The CFPB intends to increase its enforcement staff, not its total staff, its enforcement attorneys by 50%. Similarly, U.S. Attorney General Merrick Garland has been quoted recently as saying that the Department of Justice has another 20 or so pending investigations into lending discrimination. These are hot issues in this administration right now. The CFPB has been extremely active this fall, and we expect it to continue to be so coming up. And the Department of Justice is the same. Go to the next slide. So we'll see a few different themes coming up from things that the CFPB, the FTC, the state attorney generals have been interested in. And those themes will be RESPA. There's a renewed interest by RESPA, both by the CFPB and by some state attorneys general. We'll see a focus on junk fees, which Trip's going to talk about. We'll see a focus on revisiting former consent orders and a real focus on fair lending. So let's start out with RESPA. The CFPB has been busy with RESPA this year, issuing one consent order regarding alleged violations of Section 8A's prohibition of referral fees and kickbacks, and issuing back in February of 2023 what it terms an advisory opinion, which is really just interpretive guidance on the use of digital mortgage comparison shopping platforms and how that can possibly be a violation of RESPA, or how the CFPB really is going to view it as a violation of RESPA. So the consent order and the guidance both bring RESPA back into the Bureau's crosshairs. The consent order involved marketing servicing arrangements, which the Bureau has considered to be a problem for years. But the Bureau here, between these actions, really attempts to be writing out or diminishing the effect of Section 8C2 of RESPA on the rest of the statute. This is important to watch out for because both of the items on the screen here include services actually provided and services in some form actually paid for. So they appear to meet the statutory requirement, at least the base language of the statutory requirement. And while the consent order trudges more familiar territory for the Bureau on this issue, the advisory opinion really goes a step beyond. The standard they set out concedes that payment was provided, and it appears that the CFPB concedes that the service was provided too. But here you'll see in both the consent order and the advisory opinion, what the CFPB thinks is that you're paying more than the reasonable value of the services provided. And that's the important takeaway from these two things, is that the CFPB believes in these situations that the party is paying more than the reasonable value of the services that are provided under 8C2, and that's why they don't come under the statutory exemption. This is particularly interesting with respect to the digital mortgage comparison shopping platforms, because it really seems to be the way that digital advertising works, is that you pay more for a more prominent presentation on whatever the digital platform is. And the CFPB appears to be taking the position that that more prominent positioning on digital platforms is a violation of RESPA. It's hard to reconcile with the language of 8C2, particularly with the advisory opinion, and with the PHH v. CFPB case from 2016, in which the DC Circuit reinforced the statutory control over the interpretation. That is, there in the CFPB case, the PHH v. CFPB case, the DC Circuit said very clearly that as long as the reasonable market value has been paid for the services provided, whatever that reasonable market value is, then Section 8A doesn't apply. 8C2 exempts the transaction entirely. So I think that we'll see, as the CFPB goes forward, trying to enforce or apply, particularly the advisory opinion, some pushback with respect to that. Also in RESPA, the DC Attorney General has recently taken a fairly aggressive position on affiliated business arrangements and terminating them illegal under the local DC statute. They allege that DC statute silence on affiliated business arrangements equals a prohibition on them. Now, this is an interesting way to read the statutory prohibition or statutory language itself, but that's the position that the DC Attorney General is taking. It's a fairly aggressive one under RESPA. Next slide. So the CFPB is also revisiting old consent orders. They've recently revisited civil action over HMDA violations that they allege are violations of a prior consent order, UDAP violations they allege are a violation of a previous consent order, and another UDAP case against the online small dollar case lender alleging violations of a 2019 consent order. So let's move to the next slide and we'll talk about the first one of these. So in April 2015, the CFPB originally entered into a consent order with a non-depository mortgage lender. They alleged a variety of marketing violations, including failing to include TILA-required disclosures and unfair and deceptive misrepresentations that basically made the advertisements look like they were coming from the government, from the FHA or the VA. In February of this year, the CFPB entered another consent order, finding that the company had sent millions of advertisements in violation of the same regulations and in violation of the 2015 consent order. As a result, the CFPB issued, or the company agreed to, a permanent ban from engaging in mortgage lending activities and a $1 million penalty. So we'll see this. The CFPB, in response to these, what it perceives as violations of previous consent orders, is seeking much stronger or more injunctive type remedies against the companies. Here, a ban from engaging in mortgage lending. And the next slide, we'll see that against the online small dollar lender that the CFPB recently issued a consent order against. They also issued injunctive relief, preventing that company from issuing certain types of loans in the future. They also, for this company, issued injunctive relief requiring changes to the executive's compensation policies. So for this particular consent order, the Bureau found in 2019 that the company had failed to honor certain extensions it granted to its consumers and that it debited consumer bank accounts without authorization. In the current consent order, they found that the company continued to do that. At least they allege that the company continued to do that. Next slide, please. As a result, the Bureau, as I said, banned the lender from offering those same types of loans, required it to incorporate certain provisions into executive compliance policies, and issued a $15 million consent order.
And Jason, I think that in the future, as the CFPB looks back at these consent orders to make sure that the companies have been following them, and you mentioned how they're sort of trying to impose certain injunctive relief on executives and so forth. I think we're going to see them be even more aggressive. And they're going to try to either ban certain executives from participation in the market and or hold them responsible, not just the company, but them individually responsible going forward. What those penalties will be, I'm not sure, but I think they're going to hold them personally responsible to make sure that the changes to the policies and procedures and compliance with the consent orders is being achieved.
I think that's right, Tripp, and it's less an exercise in what they might be doing, and is actually happening. There are a couple enforcement actions that have been going on for a few years, where the CFPB has brought in the executives and brought in the owners of the company, and trying to tie them to those same violations. And those cases are ongoing, and we'll see how the courts deal with them. But there are some cases where those executives have already been brought in, Tripp. And so we'll move to the next slide, and Tripp will talk a little bit about junk fees.
So, this notion of junk fees is almost like pornography back in the 70s. The CFPB knows it when it sees it, and it won't tell you that it is a junk fee until they've decided that it's a junk fee. But most recently, the CFPB, the FTC, state of California and others have issued these guidance and some legislation regarding junk fees. And you can find them at the CFPB's supervisory highlights and FTC in California's websites. But in any event, what the Bureau is trying to do through the supervisory guidance and so forth is to provide roadmap, not only for themselves, but for other agencies to determine whether or not certain fees are junk fees. Basically saying we on high know best, and you should follow our guidance, even though it's just CFPB guidance. Next slide. So one of the most recent consent orders that focus on junk fees is the consent order with the CFPB around remittance transfers. And they basically said that this company that was doing remittances had violated the Electronic Funds Transfer Act. And really the way they did that is they said that under the EFTA that there were certain requirements for notices about fees and so forth required under that act to be provided to the consumers. And again, they said that those notices weren't provided, as well as the company was providing incorrect fees or fees that did not comply with the prohibitions of the EFTA. But again, while there's certain they're interpreting the EFTA that way, what they really are doing is saying that this company was being abusive towards a protected class, immigrants, non-English speaking. And you've heard me speak before, the notion of abusiveness is really front and center for these junk fees. Abusiveness for the CFPB is they look at the category of consumers. So in this case, immigrants and non-speaking English populations, and say they are in a uniquely vulnerable position relative to the service that's being provided. They want the service, they need the service, they need, in particular here, to get money back to their family overseas or in Latin America or where have you. So they're really sort of bound to use these services, and the Bureau found that this and other companies are taking advantage of that desperate situation that they're in, or a situation where they are at the whim, so to speak, of these companies. And so if you are providing services, financial services, to a category of customers or consumers who are in a very vulnerable situation, you are opening yourself, and it's good you're doing that, and you're doing it correctly. But if you deviate, from that, or could be seen as taking advantage of this desperate situation, you should be paying particular attention to your compliance. Next slide. Also, there was the consent order with Bank of America over its non-sufficient fund fees. Again, consumers were charged every time the merchant tried to take money out when there wasn't enough money in the account. And the Bureau here said, look, it's not really a junk fee, but it's, they'll define it as a junk fee, but really what the problem is again, lack of notice that this was going to occur. So it really didn't give consumers a chance to react. At least that's their view. And again, this was all about being abusive. People need to use their credit cards, or they need to use their bank cards for a variety of reasons. And so they again saw that these fees were taking advantage of whatever the situation was with the consumer that put them in a vulnerable position. Next slide. This to me, this One Main Financial, which has really spiraled to other consumer financial service providers. In fact, the actual providers of these add-on products, I know from my own experience, have been hit with CIDs and subpoenas. And again, it's just an example of how the Bureau moves, and the FTC moves from sort of the top of the pyramid to down through the bottom. And so here, One Financial was providing consumers with these add-on products. It might be home protection plan, it might be underinsured protection, and things of that nature. And some of the things that the Bureau was saying is that the consumers didn't even know they were paying for these things. But most important, the issue was this full refund. So One Main would say, hey, why don't you sign up for all of these different protections? This is why it's important, and so forth. And the consumer says yes. And by the way, or before the consumer says yes, the One Main says, but if you don't like them within this period of refund, you will get a total refund. And so what most people would say, all right, well, if I pay $100, I get $100 back. But One Main was financing most of these products. So what would happen when you finance? Obviously, you have you have interest. And so One Main was returning the $100, but not the finance charge. And in some respects, the Bureau even said, not only did you should have returned the finance charge, but you should have also included the amount of money that $100 could have made in the market or sitting in a bank account. That's a little aggressive, I would say, but in any event, that was the focus. So again, for you out there, whether you're in the mortgage space or the auto space, if you're providing these add-on products and charging interest and also allowing for a refund, this is a clear takeaway as to how you should react, because the consent order gives you that roadmap of what the Bureau's thought process is on this total refund within a refund period. Next slide. There are a couple of other, again, we can see how from One Main we move on to Toyota Motor Corp, same basic issues. Again, this add-on, whether it's GAP or any other type of financial product. And here, it wasn't really the return or refund, but again, notice to the consumers how to cancel the add-ons. And again, making sure that they got refunds. So if you're going to have, the takeaway for this on this case is that if you're going to provide these add-ons, and whether you're going to allow the consumer to finance it or not, you must have very clear procedures, not only internally, but externally so that the consumer really cannot have any hiccup in ability to cancel or understand any of the cancellation policies and procedures and so forth. And this is a big hit in this area. And again, it's this year, just recently. So it is really evident of where the Bureau is going. $48 million for consumer redress and a $12 million civil money penalty, along with injunctive relief. This is in a very, very aggressive resolution. So we can only imagine where the Bureau started. I'm sure it didn't start at 48, probably several multiples of that, along with $12 million civil penalty. Just a word to the wise, this along with One Main are really important cases or consent orders to look at, to understand and figure out how it applies or could apply to your situation. Next slide. Another case, which I'll quickly go through, which you can take a look at, Atlantic Union Bank, $26 million, again, an EFTA and Reg E violation, again, going to disclosures, again, regarding the fees that would be charged. And it's really, again, the focus, while they say there was improper disclosures and communications with the consumer, really what the Bureau is going after is the fees themselves. And so if you're going to have some of these fees that are talked about in these cases, you're really, again, because they're being looked at, they're being scrutinized, you really need to make sure that your internal process and then your communications to the consumer are, not just 100%, but 110, 120% risk adverse. Next slide.
In Trip, I think talking about the fees and the overdraft fees in particular, the CFPB recently came out with a report on overdraft fees specifically, and found that there are a lot of banks, some smaller regional banks, that make a lot of profit off overdraft fees. What do you think about that in respect to this? Do you think, you talked a lot about the abusiveness of the fees as well? Do you think that's driving some of the CFPB's press on this?
Well, yeah, look, the Bureau's view across the board is that a company shouldn't profit by the mistakes of the company. So one of the things that the Bureau will look at when they go into a fee issue is it a fee that covers the cost of dealing with, whether it's an overdraft, whether it's a cancellation, and so forth. And looking again, is the cancellation or the looking for the fees, are those, number one, are they the result of the consumer being in a difficult situation that they may not necessarily have control over or not complete control over? Number two, they don't want to see financial services companies making a profit. They can cover the expense, right? And so that's a good argument if you can say, well, if you're investigating, these fees really just address the cost that's associated with whatever's happening at the consumer level. But if you're making millions of dollars off of a process, and we can sort of do a reverse, like the pay to pay type of situation, where, hey, if you typically pay by check, but we'll give you, within the 3 days before it's due, we'll give you a chance to pay by credit card, or wire, or some other process that seemingly helps the consumer address the urgency of the situation and the inability to get payment in the normal course to the provider. that's fine. That I think the Bureau would say that's fine as long as what you're receiving is payment that covers your costs. But when you're starting to actually make money off of that, whether it's the provider of that service, the money processing company, or where the money processing company is charging $10 and the financial service provider is getting 5 of that for doing nothing, other than providing the opportunity to deal with the payment processor, that the Bureau cannot stand. And so it's, again, something you need to look at very critically.
Great. And so we're going to move to the OCC's recent guidance on buy now, pay later. And the BNPL product has been heavy focus of not just the OCC, but really the CFPB over the past year and a half. The CFPB has issued a lot of research, of guidance, of different types of material regarding the BNPL product. So it's clear that the CFPB has the BNPL product in, if not its crosshairs, in close to its sights. It's looking at the product. It's deciding what it wants to do with it. The OCC came out with guidance too. The OCC's guidance is more about risk management for banks that hold these products. What a BNPL product is effectively, it's often called pay in 4 or buy in 4 as well. It typically has 4 or fewer payments. There's 0 interest or finance charge on them. And the way that the company typically makes its money on it is that the bank is getting the full amount of what was paid, and the merchant takes a discount in order to get the product purchased at that time. So you have a delta there between what the merchant gets and what the bank will get. So this guidance covers a variety of different things working on risk management and portfolio management for banks that hold them, including charge-off practices, allowance for credit losses, fraud and third-party risk management, which is a big issue everywhere, of course, and then compliance risk management with respect to advertising and disclosures. Now, the advertising and disclosures is where the CFPB is really interested, because they see the market for BNPL as really primarily underbanked people and younger people who don't have as much of a credit history. And they worry about the advertising, the disclosures, how the fees that could be imposed for late payments, how the transmission of the funds will be made. The CFPB is very concerned with those things, whereas the OCC is concerned about the risk management. Next slide, please. So fair lending has been a hot topic as well. CFPB and the Department of Justice have both been very active in fair lending. The CFPB recently entered a consent order for discrimination against Armenian Americans, really one of the first times we've seen such a narrow ethnic group involved. CFPB continues to prosecute its case against Townstone Financial, which is on the very controversial redlining under ECOA topic. And for those of you who don't know, the district court dismissed the CFPB's case because ECOA only covers applicants. Now, the CFPB's theory in the Townstone Financial case really goes after prospective applicants, goes after people listening to a radio show, and whether or not comments made on a radio show will discourage people from even thinking about applying to that company. The 7th Circuit hearing on this happened last Friday, and the chief judge of the 7th Circuit said on that panel she was very skeptical of the CFPB's position, but we'll see how the other 2 judges come out on it. DOJ,
and I would just say, Jason, that it's not only just the advertising on the owner's own sort of podcast or radio show, which, the language is problematic, of course, just from a public perspective. But it was also things that I think that are missed in it. The complaint also made allegations about the company not having enough minority employees and not having offices or doing advertising into particular areas of concern in Chicago. And this is a small lender. I mean, it is a lender, but it's very, very small. with limited resources. I mean, it's not making hundreds of millions of dollars a year, or even, $50 million a year in revenue. So that's an important aspect that the Bureau seems to think that they can expand to prospective purchasers, not just based upon language broadcast, but the activities of that lender that they just simply think are non-responsive, and basically say, well, you're not advertising in this area, or you don't have enough minority employees, and therefore you're pushing potential applicants away from your business, which I think is particularly problematic.
And they're important points, because we'll see in the next few slides that these issues come up again and again in fair lending settlements these days. But it's also important to note that the things you're talking about, Tripp, are really an analysis or a view of a non-depository mortgage lender through the lens of the Community Reinvestment Act, which doesn't apply to non-depository lenders. And the CFPB has been attempting for years. The Townstone financial cases is sort of the culmination of all these actions, but the CFPB has been attempting for years to apply ECOA through a redlining theory in this manner, using just those types of Community Reinvestment Act types of tools. Yep. Next slide, please. So on just late last month, just after Thanksgiving, the CFPB entered a consent order with the large national bank alleging widespread HMDA violations. And so you'll see this is the second time that HMDA has come up in this presentation. HMDA is clearly an increased focus of the CFPB. HMDA has been one of the more quiet statutes that the CFPB has coverage over during the CFPB's tenure. I can think of one, outside of this year, I can think of one consent order that was issued under HMDA prior to this. And now we've had 2 actions this year under HMDA. So here specifically, the CFPB alleged that the bank was purposefully not collecting the data that's required to collect under HMDA, and then effectively lying about what the consumers told them about that data on the applications. There's a $12 million penalty under this one. Next slide. Earlier in November, the CFPB also issued a consent order with another national bank stating that it violated the Equal Credit Opportunity Act for treating applicants of Armenian national origin differently than other applicants. This was a $24.5 million civil penalty and $1.4 million in redress. Next slide, please. And then here is the Department of Justice's most recent settlement for a bank in Florida. Here, allegations of redlining. Here's where we see the Community Reinvestment Act lens come into place, really in its proper location, which is with the bank, a national bank that is covered by the Community Reinvestment Act. So the allegations are that between 2016 and 2021, the bank avoided providing mortgage services to majority Black and Hispanic neighborhoods in Jacksonville, Florida. It alleged specifically that the bank had 18 branches, but it never operated one in a majority Black or Hispanic neighborhood, and therefore it was not serving the needs of its community. The bank, as a result, agreed to invest $9 million to increase credit opportunities for communities of color throughout Jacksonville. Next slide, please. Tripp, why don't you take us through the EFT action here?
All right, well, we've already talked, obviously, a little bit about the EFTA actions. So I think that we probably could skip this, Jason, because I think we talked a little bit about that earlier. And so why don't we go to the next slide? So student loan servicing is a hot topic for the CFPB and for many, if not all, state AGs. So we just wanted to note that the Wall Street Journal reported at the end of October that the Department of Insurance withheld up to $7.2 million for failure to timely send out billing notices to millions of borrowers. look, everyone knows that time for repayment is on us. There is no more forbearance anymore, or limited forbearance. And so the CFPB and the Wall Street Journal picks up on this, is going to be looking at, and I guarantee you that the states, California, Pennsylvania in particular, who have been super active in this space, are going to start looking at, through CIDs or other type of investigatory methods, to see how the servicing of is being done now that the forbearance is over.
Hey, Tripp, do you think it's coincidental that this was released about Mohala after Mohala won its Supreme Court case against the student loan?
Well, I think that it is likely that on background, the Wall Street Journal had some discussions with the CFPB. And so this was not just the Wall Street Journal saying, "Oh, well, this is interesting. Let me report on it." I really think that the Bureau probably pushed that article. So next slide. So there's also the consent order related to the CARES Act with Carrington Mortgage. In there, the CFPB alleged that there were violations of the CARES Act, again, charging late fees despite borrowers having COVID-related forbearance. Also alleged that they told borrowers that their monthly payments were due immediately, again, despite that forbearance. Then, of course, the biggest problem, or one of the biggest problems, was the reporting of delinquency when, in fact, there was forbearance. It wasn't a huge monetary payment. I mean, any amount is a lot, I guess. But in terms of the overall, I was surprised sort of at the low end of this, given the Bureau's otherwise, interest and other actions we've seen in this area. So next slide. We also had, and Ryan spoke about this a little bit, we have some consent orders with TransUnion. Here, TransUnion, which is a consumer reporting agency, and it provides tenant and employment background check screening reports to thousands upon thousands of rental property owners, management companies, and so forth. And the CFPB alleged that TransUnion's rental screening violated the Fair Credit Reporting Act by failing in numerous ways. They didn't have reasonable procedures to assure maximum possible accuracy. And when it obtained criminal and eviction records from third-party vendors, the identity of the third-party vendors as a source of the record is not disclosed to the consumers. So again, this is, in my view, these are technical violations of this of FCRA. But again, what we see here is the Bureau expanding its regulatory interpretation of the Act, where to apply it, how to apply it. And so we really have, almost instead of a gray area, we have a black area. And the takeaway from these really are, again, looking at whether or not you have a classification or characters or a grouping of consumers who are in a particularly vulnerable space. While this consent order didn't talk about abusive, the way I read it was that's exactly what the Bureau was focusing on. Next slide. I think that's Jason.
Yeah. So at the end of last month, the Massachusetts Attorney General entered into what they call an assurance of discontinuation, which is, for all intents and purposes, a consent order with Rent-A-Center regarding alleged violations of the Massachusetts state debt collection statute. Now, this was an $8.75 million penalty that they were required to pay. Allegations regarded abuse of the state's criminal process by the AG alleged that the company was filing applications for criminal theft and larceny complaints when its renters failed to make payments. So they agreed to discontinue that practice. Also alleged there were excessive calls to homes in violation of the state statute, which limits the number of calls that can be made to a consumer's home during the week, and also failed to notify consumers of home visits or repossession attempts, which the AG alleged resulted in confrontations with the renters, with the consumers whose houses the repossession folks were going to. Next slide. And then the next thing we're going to talk about is a recent consent order the FTC entered with really a fintech company called Bridget. They go into business BRIGIT. The actual name of the company is slightly different. But what they do is they advertised a service where people signed up and would pay $9.99 per month. And as part of that service, they could get quote unquote instant cash advances of up to $250 and cash transfers that were quote unquote free. But according to the FTC, the company did not advertise well enough that $9.99 per month fee, or that consumers had to pay an additional 99 cents to obtain the instant transfer. If they didn't pay it, the transfer could take up to 3 days. Additionally, they allege the company didn't disclose that most consumers would not qualify for the entire advance, the entire $250 advance, and a large portion of users didn't qualify for any advance at all. So these are sort of more standard FTC UDAP considerations: misrepresenting the product, what's available, who it's available to, and under what terms it's available. So as you think about complying with FTC advertising regulations, those are really the things you're always looking at. You're looking at, can I back up the statements that I'm making? Do I have clear guidance to the people, to the consumers who I want to bring in? And will they know what the parameters and the terms and conditions of my product are? Here, the FTC said consumers didn't. And this was an $18 million fine paid to the FTC specifically for consumer redress. Next slide, it's over to Trip.
So we've had a lot of discussions with clients recently on the safeguard rule, its amendments and guidance. And the FTC has, as most people know, updated the safeguard rule to require non-bank financial entities, so non-depository lenders and others, to report to the FTC security breaches involving personal identified information of more than 500 customers. So this is really important for banks have been having to do that. Depository lenders have been having to do this. But now that we really have the FTC saying, it's really any company that's providing financial services, and the impact of a breach will affect 500 customers or more. And so likely you have a breach, you're going to have, unless you don't have 500 customers, they're all going to be affected one way or the other. And also important, of course, that the report needs to be done within 30 days. We've had clients, and we've certainly seen out there in the marketplace where the breach occurs and it's 6 months before anyone knows, or it's only gone out through certain SEC filings and so forth. So really the FTC has tightened the belt on this and the requirements of notice. And then the last slide. There it is. We're all talking about it. AI. We just wanted to make sure that you guys are aware, I don't know how you wouldn't be, that artificial intelligence, the algorithms that are being used, whether it's for underwriting, whether it's for issuance of, say, title insurance, or what have you, the Bureau is really interested in this. I mean, I would say next to fair lending, as a general, concern, redlining and things of that nature, that this is going to be in 2024 the hot ticket, and really the Bureau is saying, look, you can have, you can consider these algorithms and so forth, but the buyer or the consumer, the borrower needs to understand, what's happening here, and how that algorithm may affect them. I think, again, in EACOA, and if you look at the Townstone matter, can you imagine if you had a algorithm that wasn't just about underwriting for actual applicants, but sort of an algorithm that would affect how your company operated in the space towards prospective consumers. So if the Bureau had its way that it wants in Townstone, that algorithm, the use of that algorithm just for marketing, for how you move forward in the process of thinking about and strategizing over prospective consumers could be at issue. There is, of course, also a large national consolidated antitrust class action over the use of algorithms by many of these large residential rental property businesses to determine, they use this third party who has an algorithm to determine what the appropriate fair market value rent is in a particular area. The defendants, of course, are saying, I didn't create the algorithm. I don't talk to my competitors about how they use it or don't use it. Our information isn't specifically used in establishing, the rate of increase for rental prices and so forth, or decreases, however it may be. But yet, the plaintiffs are moving forward. We can see how problematic a plaintiff, an antitrust action affecting consumers could be when we think about the most recent real estate commission judgment that came out against some of the large real estate companies at $1.8 billion. And so that's this use of algorithm, I think, really needs to be well defined within your company. And it can't just be, hey, we have some vendor or we have some people within our company that have come up with these algorithms that help. The business people love it because it'll save us money, it'll save us time, it'll save the consumer time. You really need to run that through your risk management people and your general counsel's office, outside counsel if necessary, to really think about some of these, whether it's antitrust issues or whether it's unfair, deceptive, or abusive practices that are arguably supported by the use of AI. And we know it's important because the DOJ, as I said in this slide, has shown his interest, has filed a statement of interest in this action. And so whatever the settlement, if they get there, is, the DOJ is going to be at the front of the line trying to dictate, I think, not monetary issues, but certainly injunctive relief type of issues. So with that, I will turn it back to Ryan.
Great. Thanks, Trip. Thanks, Jason. I thought Colleen's presentation was a little sad and depressing, but that one may take the cake. That's not going to make any of our attendees feel real good about the current state of things in the industry. But I'm really excited for the next panel. And it's one of my favorites of our entire program. This is our in-house roundtable where we've selected a number of very knowledgeable in-house and former in-house counsel in Justin's case to talk about what they're seeing from an in-house perspective, how they're dealing with certain issues. It's also an opportunity to incorporate some audience questions this year. So if you're interested in submitting questions to our panelists, please use the Q&A button at the bottom of the screen and we'll try to incorporate some audience questions. So with that, I'm going to let our esteemed panelists an opportunity to introduce themselves, starting with Stacy, since you're on my screen first.
Hi, good morning, everybody. My name is Stacy Moore. I'm Senior Vice President and Associate General Counsel at M&T Bank. I handle litigation across all of our various entities.
Great. Justin, you're up next.
Hey, thanks, everyone, and good morning. My name is Justin Bradley. I'm senior counsel at Womble Dickinson, recently joining them to handle regulatory and compliance issues, federal, state, and enforcement actions for financial services clients. Previously, I was deputy general counsel at NewRez and head of litigation.
Great. Thanks, Leah. I see you up next.
Hi, I'm Leah Everly. I'm in-house counsel at Bread Financial. We primarily, our largest product is credit cards, so private label and co-brand credit cards, and some other consumer finance products, buy now, pay later, and monthly installment loans. I primarily support our litigation practice group, as well as our consumer services regulatory practice group, focusing on collection issues, TCPA, FCRA, and MLA.
Great. Last, certainly not least, Irina.
Hey, good morning. My name is Irina Popova. I work for Maximus. Maximus recently novated over Navient's federal student loan portfolio, and we operate under the name of Aidvantage. So I work as regulatory counsel for Aidvantage, certainly working to set up a compliance management system kind of under a new company with this new business line. I also manage the litigation portfolio for Aidvantage. Previously, I worked for BPO GC Services. I was in-house counsel there, managing litigation and compliance matters. GC Services did first-party and third-party work for the Department of Education, some guaranteed agencies, and some banks, and some clients in the auto space as well. So certainly that background has been interesting in terms of partnering kind of both with banks in this space and now student loans.
That's great. Thank you. I mean, I think we could park some time for why Justin came back to the billable hour and is coming back to a law firm. I think we could probably do at least 30 minutes on that, but we will move on. Before we jump in, I'm just going to set the stage with some of the latest data from October through October on litigation trends, and then I'm going to turn it over to our panelists. According to Web Recon this year, claims relating to FDCPA and FCRA have trended downward. FDCPA claims are down significantly, about 13.4% over last year. And as I mentioned earlier today, FCRA claims and filings are down about 2.1%. Interestingly, FCRA claims still are outpacing FDCPA claims by about 25%. So we're still seeing that. And I don't want to steal our next panel's thunder, but TCPA claims are up. They're up about 10%. In October alone, the filings of new TCPA claims, 69% of those filings were class actions, which means that these cases that are being filed, the majority of them are being styled as class actions, which I think is interesting. So against that backdrop, the first question I'm going to pose to the group is, have you all seen in the past year? Is litigation trending up, decreased, remained static? Justin, I'll start with you.
Yeah, Ryan, it's been really, an overall increase, single digit percentage increase in litigation. That being said, the rate of that increase has been dropping pretty substantially. And so while it is still increasing year over year, it has slowed quite a bit. Now, a lot of that litigation is being driven really by these foreclosure responsive filings. So I would say 2023 was the year that foreclosure really resumed, right, after all of the moratoriums from COVID. And so that really drove that litigation to come back. And as we see across the industry, there's a lot of foreclosure starts. There's not a lot of foreclosure completions happening. But that doesn't mean that those homeowners, many of them have a significant amount of equity, are not going to challenge the foreclosure process. So states like California, Texas, where the way you challenge a foreclosure is actually by bringing a new lawsuit, that has really come roaring back this year. And then, of course, you have the contested foreclosures that have really drug on, and that's led to a big increase in New York because of FAPA this year. And for those of you that aren't familiar with FAPA, the Foreclosure Abuse Prevention Act, really focus on statute of limitations and accounts that may be potentially out of stat because of prior foreclosure actions or things like that. So all of that has led to those increases. Outside of those categories, though, really it's been decreases across the board, which I think is overall, certainly has been good as we've looked at the portfolio.
Leah, what are you guys seeing?
Yeah, so I think it's interesting that while Web Recon shows the slight decrease in litigation, at least how we define our portfolio of litigation includes things like arbitration, some pre-demand suits that aren't necessarily reflected in those statistics. So for us, we've seen an increase in what we term litigation, which would include things like arbitration and the pre-demand suits from plaintiffs' attorneys. A pretty significant increase. Largely driven by exactly those things that wouldn't show up in public statistics necessarily.
Stacy?
Sure. So at M&T, and I'm speaking for myself, not on behalf of the bank, we really haven't seen an increase in mortgage litigation. I think we did an incredible job with our modifications. So we've actually seen that trend down a little bit. Foreclosures haven't picked up too much. We are seeing a significant increase in litigation when it comes to our retail areas and check fraud. Most of the other areas are stable or some trending down. So, that's what we're seeing, but really check fraud and a little bit of an increase in discrimination as well. So
any ideas on what's driving that? Any root cause analysis yet, or still to be determined on the check fraud increases?
If people would just stop using paper checks, I think we'd all be a lot happier.
Irina, how about you? You guys are kind of in an interesting situation. So what are you seeing from a litigation perspective?
I mean, we're just, or at least I am absolutely stealing myself for kind of an onslaught. It's very, very hard to know what will happen even kind of in the next quarter. I saw on the last presentation, obviously, the student loan payment pause just been lifted, payments have resumed. I don't think that we can even kind of extrapolate over the last 3 years and anything kind of meaningful that we'll be seeing in 2024, but kind of fully anticipate an increased litigation. I mean, as of right now, there has been an increase in FCRA litigation, certainly. And in the federal student loan space, as a student loan servicer for federal student aid, there's kind of unique issues related to FCRA claims, because clearly with regard to indirect disputes, reasonable investigations thereof, you're reviewing credit reporting by any servicer that functionally touched the loan during the life of the loan. So that has presented its challenges, certainly, in terms of reviewing complaint allegations.
Yeah, I think you guys are in a really fascinating case study, which is I'm not sure of any industry where collections have effectively stopped for 3 years. I mean, Justin, you talked a little bit about foreclosure, forbearance and that pause. And certainly I would imagine that led to a significant decline in litigation, but it didn't stop litigation. I mean, effectively, Irina, I think the litigation trended almost to zero, right?
Yeah, functionally almost to zero. And it's very hard to do any kind of trending legal exposure analyses and to our leadership, certainly, during when you have basically almost nothing to compare it to. In terms,
yeah,
I mean,
the takeaway is, right, if you want to stop litigation, just stop collecting, right? I mean, it's just that easy. Just stop collecting on all the accounts.
Get rid of the servicers altogether. I think
exactly.
Whatever's out there is out there. Yeah.
Yeah, I think what we're seeing with our portfolios that we manage kind of matches more what Leah said. We're definitely seeing static, in terms of filings, but we've seen a real significant uptick in the pro se litigations, which I'm going to kind of pivot to next, which is, has anyone else seen the increase in pro se sovereign citizen type disputes? And then kind of how are your companies dealing and addressing those? Leah, I'll start with you on that issue.
Yeah, so I'll address the sovereign citizens first. I'm not sure how our disputes are trending. I know every now and then I'll get one forwarded to me because someone's not sure what it is, but we do have a process in place on our front line to address and respond to those, kind of a generic non-response, because we give them, I think, the time that they deserve, which is minimal. As far as like pro se and credit repair networks, we have seen it, again, I mentioned increase in those. That's what's largely driving what we include in our litigation portfolio. A lot of the pro se claims are also, we can track back to credit repair networks that are doing a lot of social media campaigns in order to find their clients, loosely speaking. It's funny, when I will try to look up one that we're aware of, I will then get others fed to me when I'm just casually looking at the internet. So I've seen them pop up on like TikTok, Instagram, and we've seen them on YouTube, at least from where our cases are coming from, where these networks, really non-attorney networks, are out there having these campaigns to sign people up and then acting as their non-lawyer representative, which then is how we get these pro se claims. So a lot of those.
Leah, what's the approach been? How have you guys kind of dealt with them from a 30,000 foot view?
Yeah, so in the past, I think our approach this year it's almost a 180 from what.
Oh, Leah, I think you may have gone on mute.
How we've dealt with them in the past. So in the past, hello?
I got you.
Can you hear me?
Yeah.
Okay. I didn't touch anything, but it must have been a network issue. Let me know if that happens again. But in the past, we did not give much time to pro se claims because they were one-offs. One-offs and kind of went away after we dealt with them. Might pay a nominal amount of money because it just was cheaper to do it that way than to fight it. Now that we're seeing them pop up through these credit repair networks, taking a totally different stance, fighting back significantly, not really giving in much, if at all, particularly where it's tied to a network, to try to shut down the network, at least coming to us. If they go somewhere else, I guess they go somewhere else. But to avoid the repeat where they think it's a low-hanging fruit and that we're going to cave in, because we are not in those instances now. Yeah.
Irina, how about you guys? Have you seen any increase in kind of the pro se credit reporting specialist type actions or pre-litigation disputes?
Not really as of yet, Ryan. But I mean, certainly we keep a watchful eye over our Office of the Customer Advocate, because that's certainly, is usually the bellwether for kind of what's to come. And
I would say if complaints are trending upwards, then you're probably going to see it. That could be a leading indicator. So if your complaints, your consumer advocates are up on the credit reporting side, like some of those cases are going to probably end up in litigation.
Absolutely. And I mean, I think what we've been focusing on is partnering with federal student aid in terms of, these credit repair organizations that, I mean, are just functionally charge borrowers for, services that, they can get for free. And certainly there's been a huge push to fight back on those with FSA support. So that's kind of front of mind, maybe not exactly in this context, but I see that as a possible, kind of problem down the road as well.
Yeah. Justin, how about you guys? Did you see any of this stuff at New Res, Shell Point?
Yeah, it was a pretty frequent, type of complaint category that would come in. And like the other panelists said, a lot of that largely is within our complaint team. And so they're focused in on those. One of the things that I think is really, helpful though, is being able to keep an eye on those statistics and look at, how you can treat some of those and really identify the right categories to effectively treat like you would litigation, right? And so, I don't just mean negotiating settlement, although in some cases, maybe there's an opportunity to go ahead and get a release and get it resolved before it even becomes litigation. But what I'm really talking about is, the same type of process that the litigation team would do when doing investigation and looking at the facts and really trying to get to root cause analysis, making sure that your complaint team has access to do that. Or, for example, if it is credit reporting, not just looking at the data that also led to that reporting, but looking at the underlying data to make sure it's correct. And so, if you're have a dispute that's coming in saying, actually did make this payment, well, trying to look at some of that and get ahead of it. And some of these, ultimately just end up being nonsense. And there's a lot of, as one of the earlier panels was talking about, a lot of focus from these filers to try to create and manufacture these type of claims. But that doesn't mean you can't still do, and you shouldn't still do, a reasonable investigation and dig into the underlying facts and look for those issues that may ultimately lead to litigation down the road. And so in doing those kind of processes, we've seen, certain categories of these complaints actually that led to litigation go down by 90%. And just trying to get ahead of those issues in the complaint process before it ever becomes litigation.
Yeah, I mean, I think FCRA is definitely one of those ones that I see in that area, right? So if you're getting disputes, you can certainly handle and get out in front of some of these issues on the dispute side and through the credit reporting team. Stacy, I feel like you're going to be our optimist today. I know you mentioned you're not seeing a lot of this, but I did want to give you an opportunity to chime in.
Yeah, so I would say, look, if I bucket them differently for pro ses, we see a lot more small claims, but they're not in the credit reporting. I just want to knock on wood as I say this out loud. Our credit reporting group is phenomenal. They take a very hard stance. We do not settle cases. We will fight them because we are really proud of how we report. We'll correct for inaccuracies or things that we think are confusing, right? But we really stand behind our team and our people on that. And that's really brought FCRA litigation down. So we don't see a ton of that. We do see sovereign citizens. And again, we take a hard line and fight those. We are seeing, and I've probably seen 10 or 12 of them in the last year and a half, fake arbitration awards from sovereign citizens, which has been really funny because my branches get really panicky and they're like, oh my God, I just got a $2.3 million arbitration award. Do we have to pay that? And you're like, no, I think it's fake, guys. It's completely fraudulent. So
that's crazy. I mean, so just to put a finer point on that, someone is sending you one of your branches, a fake judgment that says,
yes,
hey, John Smith, $2.3 million. Is that right?
Yep. And it has, UCC language. It has everything you would expect to find. It doesn't have the, thumbprint in blood, but it's just, it looks official if you weren't a lawyer. And as you're a lawyer looking through it, you're like, this doesn't make sense. It even has lawyers listed on it. So, we've referred a lot of these to law enforcement agencies for prosecution because, they're just absurd.
Just fraud. I mean, that is criminal attempted fraud is what that is. That's crazy. So switching gears a little bit, we've seen a regression over the past few years after the DeGoy decision on TCPA litigation. But we've noticed a bit of a bump this year. So kind of interested in the group's thoughts on, are you seeing any increase in TCPA related litigation? And if so, what areas? Leah, I'll turn it over to you to start.
I think we've seen, maybe similar to what you had mentioned at the beginning, a slight increase in TCPA. I wouldn't say anything material. At least the areas that we're looking at and paying more attention to are pre-recorded calls and reassigned numbers where those pop up, which again isn't driving that increase, I would say, but where they pop up, we pay more attention to them.
Yeah. Justin, how about you?
Yeah, nothing material. The limited cases that we have seen all stem from do not call allegations, and that's primarily from prior practices around lead generation, which obviously has been under a lot of scrutiny, both from a litigation and regulatory aspect. The other thing that just frequently comes up, and I think that almost all of the cases that we've seen that are TCPA related have all come from these frequent filers, right? The individuals that are just incredibly litigious, filing 40, 50, maybe over 100 cases, out there. And of course, they use pseudonyms and other things to try to avoid being caught by litigious filers. They have very sophisticated practices. I was reading a deposition of one recently that sued one company, and his wife submitted a complaint so that when they were seeking complaint data to try to identify other potential members, they would know if they didn't get all the complaint data because they would have had the spouse included in there. That spouse actually sued another client in another case, and they did the exact same process, just flipped. And so they have very sophisticated tactics, very creative, that are leading them to continue to file these cases over and over again. And have really, again, manufacturing these claims, right? Submitting the data in a way that is going to lead to these type of cases, and they're just looking for those opportunities.
Yeah, we have a question. I mean, is the trend in legal issues for TCPA cases, are they auto-dialed cases? So just to jump us off there and respond to that directly, like, I don't think that the risk in these cases is auto-dialed, right? So for me, what I'm seeing is the risk in these cases is through the pre-recorded voice messages. And one in particular, that area that I'm seeing that I'm concerned about is pre-recorded voice messages on hold messages, right? So I don't know if anybody else is seeing this, but I've heard one theory advanced this year where you're using a predictive dialer to make your calls, and at the same time, someone is they're put on hold for a short period of time, and there's a message that's played, right? Please wait for a representative. And in that case, the argument is that even though you're using a predictive dialer that connects you to a live agent, that hold message constitutes a pre-recorded call. So I don't want to steal the next panel's thunder, but certainly interested if anybody else has any thoughts.
I can chime in on this one. So that is something that we had been doing in the past, which was playing if our dialer dialed too quickly, I guess, and there wasn't an agent yet available, playing a please hold for next available agent. I can say we have adjusted now our business practices, kind of in light of where we think there might be some risks there, and now we play what I'll call like elevator music if it is a hold instead.
Yeah, so I guess as ridiculous of a distinction as that kind of is, right? The idea is that music isn't a pre-recorded voice, right, Leah?
That's kind of where we have come out, is we think there's a much lower risk where there's not a voice or a pre-recorded voice in the elevator music.
Yeah, and I think that's the best you can do, because something has to play, right? I mean, it can't be dead air. So anybody else have any thoughts on the TCPA before we move on? Okay. We touched a little bit on FCRA, but are there any FCRA specific claims? Are there any areas of collection activity that you're seeing create problems? Justin, maybe I'll start with you on this one. FCRA claims have largely been static, but are there areas of concern that you were seeing?
Yeah, a lot of the focus has been on, coming out of the CARES Act, right? And so these COVID era forbearances, borrowers that are exiting those, and then going into other workout options. And so that really has been the focus. I will agree with you, Ryan. I think you had an earlier comment that there is a lot of focus on trying to really drive up the market value of these cases by plaintiffs' attorneys. And that certainly has been my experience as well. You tend to see a number of these players very frequently. They're really trying to drive up that market value of these cases and increase that where they can. And so, yes, they are, not as eager to try to settle those cases. And so that really is the focus. But that also has led to a lot more new entrants into this space, newer plaintiffs' attorneys that we haven't seen over the last few years that are really trying to make, especially this COVID era kind of, workout related reporting, really just their MO, and that's been their focus.
Yeah, Irina, anything from you on the FCRA side? Anything that you're seeing?
Ryan, not so much from a litigation perspective, but I mean, just to agree with Justin, I mean, there are customer complaint issues just kind of on the other side of it, which is I mean, frankly, it all just largely, comes from the fact that this was, and we've used the word unprecedented and an unprecedented number of times in the past few years, but such special rules related to COVID, borrowers coming in and saying, my credit report isn't what it could be were it not for, the student loan payment pause, were not for the specific way that federal student aid has directed servicers to credit report. So, it's all to say that, even when you stop, quote unquote, collections kind of, and functionally credit reporting for a time, there's always kind of something on the other side of the coin.
Yeah, I definitely have seen mortgage servicing, student loan servicing, the booking of forbearances or plan payments have led to credit reporting disputes, right? So if you're forbearing on a payment for a period of time, that's something that seems to be driving up, whether on a trial period or just a total forbearance, it seems to be driving some of these claims. The other area that I've seen increase significantly is bankruptcy, right? Like bankruptcy just seems to be really, really a challenge for furnishers to monitor and incorporate. So Leah, what about you? Anything on the FCRA side specifically?
Nothing specific comes to mind. I think it's something that we're always looking at. Bankruptcy has always kind of been out there as one for us that we monitor where things pop up.
Yeah. Stacy?
Yeah, I was going to say, we see some bankruptcies that always causes a bit of a hiccup. Frankly, if I think about my small portfolio of FCRA cases, the biggest issue is when folks pay their loan off or pay the card off, but they've got a history of delinquencies. They somehow think that just disappears. It's really interesting. It just doesn't. And there's historical data that remains, and that even if your loan is paid in full, if you pay late, it's still going to get reported as such. And they'll file litigation. We actually just won a case in California. It took us 4 years to litigate it, but we just won. Because we think historical data is accurate data. So, but I probably have 7 or 8 of those cases. So
it's interesting. Stacey, you mentioned, I think earlier, discrimination claims, right? So I just want to touch on that. Can you just tell us a little bit more about what you're seeing, and do you see that as kind of a trend that's going to continue?
Sure. So in the past couple of years, we've seen a slight uptick of discrimination cases. Most are related to what I would term customer inconvenience. So when we decide to verify an out-of-state check is, actually valid, when we decide that we're going to pull the signature card and compare a signature, if we refuse to notarize an out-of-state document, we're seeing kind of that if it takes, 5 minutes to do something, we're going to get a discrimination claim on it. And, we've won them all, but it's been a little frustrating because they're really completely meritless. On the fair lending side, we've seen some ECOA, we've seen some redlining cases. We had a tough, case involving HUD and a nonprofit fair housing group that was completely meritless, involving appraisals. And those are just very frustrating, because as much as you want your regulatory agency to understand the issues, it just seems like they don't have that mortgage servicing background necessarily to really investigate, dig in, and understand what the law is. And so that's been really frustrating for us.
Justin, I imagine you have something to say on that.
Yeah, I won't spend the rest of our time talking about regulators lacking specific industry knowledge, but that certainly has been my experience as well, and that has caused a number of issues along those lines.
Yeah. One of the things that we've heard about in the industry for a while now is this idea of mass arbitration risks, right? So I think most of us kind of know what that means, but for those who don't on the line, it's a situation where a particular plaintiff either files or threatens to file hundreds, if not thousands, of arbitrations at once. And what this does is it creates the potential for millions of dollars in just arbitration fees alone, right? So if someone files 5,000 arbitrations, and they actually have signed up those individuals, the risk of just the fees alone can be astronomical. So, over the past couple of years, we've heard different versions of how clients are kind of dealing with this. But Leah, I want to turn it over to you to see, one, have you seen this? And two, how have you guys kind of dealt with this issue?
Yeah, so we have been on the maybe unfortunate end of having some firsthand experience with this. I guess maybe fortunate. We were a little bit early on, so our experience happened a little bit over 2 years ago now, where this was somewhat newer at the time. So we did end up making some updates to our arbitration provision as a result. We weighed a number of different things that we consider changing. Ultimately, our goal was trying to balance the extent of our changes. We didn't want to make things so onerous that it put the rest of our arbitration provision as a whole at risk. But some of the things we at least considered in weighing what changes to make and which not to make, I can tell you that we certainly beefed up. We already had a pre-dispute notice and cure provision. We made some changes there to beef it up a little bit. Things that are pretty easy, like requiring wet signature on that, making it clear that it has to be an individualized pre-dispute notice, so that way you couldn't have someone send you a pre-dispute notice with a list of hundreds or thousands of names attached. Looked at things like removing the ability to remove arbitration to a small claims court, revising the class action waiver to allow for a mutual agreement to consolidate claims. We also looked at pretty heavily the arbitration administrators that we had in our arbitration provision. We made some tweaks there. That was one of the things that we went back and forth of how drastic of changes to make. And I think we went somewhere moderate in the middle, where we removed one of our previous arbitration administrators and then made it open to also a mutual agreement of the parties in addition to having AAA in there. Individual notice to opt out of arbitration, again, just to try to get ahead of anyone that tried to opt out on behalf of a large list of consumers potentially. So those were at least some of the, we also, I guess, looked at, and we did end up updating our language regarding the cost of who had to pay the arbitration fees. So years ago now, maybe about a decade ago now, when arbitration provisions were very highly scrutinized and you really needed to make yours very consumer friendly, we did just that and had our arbitration provision such that there was certain financial incentives that we took on paying the full arbitration fee, even if we weren't required to, and we scaled that back some when we did those updates. So those are really some of the things we looked at and some of the things that we ended up changing.
Yeah, you're trying to balance on one hand, right, not making it overly onerous to put the whole clause at risk or the arbitration provision at risk, but then still trying to avoid the situation where somebody can just send thousands of these without anything else. Stacy, how about you? Do you guys have arbitration provisions, and have you seen this risk or dealt with this issue?
So we have arbitration provisions that we have greatly scaled back because of the litigation risk that we've seen. Our group disfavors arbitration from a legal perspective. It just doesn't seem like it makes sense. So the other thing is a lot of our agreements have punitive damages waivers. And so we had a couple of months where arbitrator agencies were saying, we're not going to arbitrate for you because you require that punitive damages waiver. And that was great, because then you couldn't go to AAA and try to sue M&T. And so, out of our entire litigation portfolio, we maybe have one or two arbitrations, and they're typically bigger commercial issues because we require now jams or something that's got a little bit more heft.
Yeah.
So
yeah, I mean, it's something that we're going to continue to monitor. I think it's something that continues to pose risk. I think a lot of clients have actually modified their arbitration provisions similar to what Leah described. There's also some new companies out there that are coming on the market, such as New Era ADR is one of the ones that I see frequently, that may be able to more efficiently deal with a mass arbitration, so you're not getting hit with these onerous fees. But so it's something interesting that we're certainly paying attention to. One of the other areas that we've noticed an increase this year is state debt collection claims, right? Particularly claims which apply to creditors or servicers. And there's one in particular that we'll probably talk about, which is violations of a quiet period in Florida brought by one or two specific individuals. And so, Irene, I'll turn it over to you first just to talk about, have you guys seen it, and what are you doing, and what have been some of the challenges in addressing those claims?
Yeah, we have, Ryan, and I mean, frankly, this is just vile. It's it's very hard to describe to our leadership that, you know, we're a student loan servicer. This is well, you know, I'll say it until the day I die. This is pre-defaulted debt. You know, certainly we're sending in many ways, you know, helpful communications that say, um, you know, help us with your address change or preferences. You know, even communications that don't say, you know, here's your bill. So you know, certainly the fact that this law in Florida, you know, seems to apply to student loan servicers, pre-defaulted debt, kind of pretty much anyone is you know, something that I think has it's been an interesting exercise, frankly, because it's certainly, you know, I think whereas maybe the initial reaction is to really dig your heels into the ground and say, you know, absolutely not, let's make some case law on this, you know, you know, we've had to kind of take a step back and figure out kind of operationally, okay, how do we stop the bleeding, um, and kind of work on a strategy, frankly, a settlement strategy, hopefully, going forward with regard to these, since, you know, again, I mean, this sort of thing always pops up. I think it's kind of inevitable in the business, but I think this one is kind of particularly trying.
It's ridiculous. So I'll use names, right? So Jabril Hindi down in Florida is the person that we're kind of referring to. Many of you that operate in the space know him. He's one of their most prolific filers across the country, right? And he and one other person in Florida have this cottage industry that they've created, right, where it is sending email communications at night. And most companies push these email communications out in the evening. And so he has developed a theory that when a consumer receives an email that references at all a debt, that violates Florida's collection act, right? Florida's version of the FDCPA. So, and it's created real logistical problems. Leah, I know you guys kind of dealt with this too, about how do you correct this, because you're not the ones who are sending these communications, right? This is actually done through another company.
Yeah, so I liked Irene's comment that it is vile, because I sign on to that. It is vile. So we had some experience with this where it was our statement ready email. So people sign up to receive their credit card statements via email. Pre-default, they're not, to me, it is not a true collections communication. It does say you have a payment due on the due date, which is what they asked for. And similar to what Ryan said, we were sending those out. These batch files would run overnight, and people would get them. In our case, it was like 6:30 a.m. Early in the morning, so pre 8 a.m. their local time. And interestingly, so when we had our experience with Jabril, he sent us 4 styled as class actions specific to Florida consumers. It was the same consumer in all 4 class actions, but a different account occurs for each. So that was his kind of strategy to strong arm us a little bit. We did end up, at the time when we got that claim, we were doing an internal process. We were able to change the batch process, but then we moved to an external third party very shortly after that back-end processor. Had several conversations with our business partners about how do we get that third party vendor to change. They were of the opinion that it was not a regulatory requirement, because it's not, I guess, a direct, maybe an indirect regulatory requirement. And eventually our business partners who own the relationship with that vendor took the stance of, if that vendor is going to say it is not a regulatory requirement, therefore you have to pay us to do the development at a higher rate to do the development, then we're going to ask you to indemnify us every time we get one of those if you will not change. That seemed to speak to them a little bit more, and they did end up doing the, I guess when they had to foot the bill for defending it and paying, that maybe changed their tune. So that actually did get them to do the development, to change the time when they sent the emails out.
So it can be done. That's the takeaway, right? It can be done. You may just have to be a little aggressive in the approach. Well, guys, I I love this panel. I think next year I'm going to schedule some more time for us because we're up against it. But I do want to give just everybody an opportunity to say something that they're paying attention to either now or something that they're looking forward to next year or monitoring next year, just as a potential claim, litigation, supervisory, regulatory. So Stacy, why don't I just start with you and see if there's anything you're concerned about for next year?
Yeah, I think for my purposes, our big focus next year is discrimination. We're looking at all of the regulatory actions there. And I do have a family member that works at the DOJ, and just seeing what working groups they're doing gives me some significant pause over PPP litigation and over redlining litigation. So,
Justin, how about you?
Yeah, the last panel talked about it a lot, but my focus, and certainly what I would recommend a lot of companies look at, is all of the fees that they're charging to consumers. I think this focus on junk fees, we should certainly expect a big chunk of that 50% increase in enforcement staff and attorneys at the CFPB to be focusing on these fees. But it's not just from a regulatory standpoint, it's also from a litigation, pay-to-pay convenience fees, property inspection fees, late fees. All of those have been a focus of consumer plaintiff attorneys for a long time in the class action and individual borrower context. And there's some pretty severe penalties. West Virginia is the one that always comes to mind. I know that just in the last month, there was another mortgage company that was sued under West Virginia statute related to late fees and convenience fees. That's $1,100 per violation. And it goes up every year with inflation. And so that penalty continues to increase. So I would look very closely at every fee you're charging, especially if you're doing any business in the state of West Virginia, but take a look at every state law as it affects that.
Yeah, I just have to reiterate that, right? So like we're dealing with one of these now. Justin's 100% right. If you are dealing in convenience fees or any similar type fee, pay particular attention. There is a law firm out there that is they've moved on from mortgage servicing. They're now getting into auto, and they've now started to hit student loan servicers. And West Virginia is a huge problem because I don't think a lot of people know, right, Justin, that there's no statutory cap under West Virginia's debt collection statute. So whereas you normally get an FTCPA claim that even if it applies to you in a particular state, you're thinking $500,000 cap, right? But that doesn't apply in West Virginia. So
exactly.
Yeah. Leah, how about you?
So I would say we're always looking at credit reporting, FCRA. There's always things that seems like popping up there just based on the complexity of the credit reporting system. Collections, those state collection claims that not necessarily, since we have the statement ready email issue kind of resolved, at least for now. But that is always a focus. We'll be looking at those claims as well. Credit reporting is probably the larger one for us, though.
Arena?
Yeah, so I mean, we're looking at issues just related to this, like sleeping bears coming out of hibernation type of issues, and particularly with regard to the fact that I obviously as a company we are interested and working very hard to protect borrowers. And I foresee kind of in the future from every aspect, these kind of claims, other actions coming from the notion that, kind of beyond maybe the requirements of an unsecured creditor, our company is also in some way has a fiduciary relationship with a borrower, and kind of all of the UDAP issues and such types of claims that come from any kind of communications with borrowers. So, particularly,
I think you guys have that added layer with the department kind of putting you in that position to create that relationship with borrowers. It opens up a variety of different concerns that traditional financial services companies really don't have.
Yeah, absolutely agree with that, Ryan.
So, all right. Well, thanks everybody. We got to turn it over to our next panel. Thank you guys so much for joining and sharing some insight. So, next up, I'm going to turn it over to Colleen and Kelly to finish off the presentation on the current state of the TCPA.
Hi, everyone. So Kelly and I are going to talk about the current state of the TCPA and the impact on the financial services industry. And as kind of a self-proclaimed TCPA nerd, it's been a really interesting year. So just to touch on our agenda. We are going to cover a brief refresher on the TCPA. We're going to talk about the scope of TCPA litigation post-Facebook versus DeGoid, which was that seminal Supreme Court decision that kind of narrowed the definition of an auto dialer. We'll talk about current litigation trends, pre-recorded voice calls, reassigned and wrong number claims, do not call on revocation claims. Then last, Kelly's going to touch on the Trace Act and some state laws that we're dealing with. Next slide, please. So just as a brief reminder, basically what the TCPA prohibits is using an auto dialer, artificial or pre-recorded voice without appropriate consent from the party that you're calling. There's two levels of consent that may be required depending on the type of message that you're sending. So either express written consent if you're sending marketing messages, or prior express consent if you're not. So for your run-of-the-mill collection or other informational account status calls or communications, you're going to need prior express consent to make those calls if you're using a pre-recorded voice. And what prior express consent means basically is that someone knowingly gave you their phone number in connection with an account that they have with you or a transaction. So what it's not going to include, though, are things like numbers that have been identified through skip tracing, numbers that are automatically captured and then added to an account without borrower verification. So really what has to happen is that the consumer has to give you their number affirmatively in connection with an account or transaction. So just something to keep in mind, well, probably many of you are not sending marketing texts or making marketing calls. If you're using a pre-recorded voice to introduce a mixed message call, so that would be something like, for example, you're calling and saying, here's the status of your loan, and maybe marketing a refinance opportunity, that's going to require prior express written consent because that includes a marketing component to that message. Next slide, please. Okay, so in our industry, as I'm sure many of you know, we used to see a lot of auto dialer litigation based on use of things like predictive dialers, click-to-dial systems, and other technologies that dialed from a set list of borrowers whose accounts were in collections, for example. So the Facebook decision, which was decided back in 2021, completely changed the game for these cases, at least in our industry in particular. So in that case, the plaintiff sued Facebook when he received automated text messages saying that someone had tried to access his account. The problem, of course, was that he did not have a Facebook account, and so he argued that those messages had been sent using an auto dialer. So the case worked its way through the Ninth Circuit, wound up at the Supreme Court, and what happened was the Supreme Court resolved a kind of long-standing circuit split and narrowly defined an auto dialer to mean a system that stores or produces numbers to be called using a random or sequential number generator. So this resolved a circuit split that really used to sweep up dialing technologies that our industry uses to contact its customers. So now, at least in theory, after Facebook, any device that dials from a precompiled or non-randomly generated list of consumers shouldn't be considered an ATDS. By the way, and I thought this was interesting, there's been a few challenges to the circuit court's application of the Facebook decision that plaintiffs' lawyers have tried to bring up to the Supreme Court. There was a cert denial just a few days ago from a case out of the Ninth Circuit. There's another one that's live now from the Ninth Circuit, but after Facebook, there's really not a circuit split anymore on this issue. So I don't know if the Supreme Court's going to address it any further. Next slide. Okay, so as I'm sure many of you guys have seen, after Facebook, our industry has fared really, really well on dispositive motions involving ATDS claims premised on collections calls. So here's just two fairly recent examples. So number one, this Allison case against Wells Fargo dismissed an ATDS claim based on collections calls. And this is, a great quote, and I think encapsulates the theme of how courts are treating these cases. The court held that it's implied plausible that defendant would use a randomly or sequentially generated phone number list to reach its own debtors. And it granted Wells Fargo's motion to dismiss for that reason. Same with this case against PRA. It dismissed a TCPA claim that arose from 200 collection calls to a single borrower, which equaled out to about 17 calls a month. Now, this type of case would have been really concerning from a TCPA perspective, at least pre-Facebook, but it's really kind of a non-issue post. I will say, depending on what jurisdiction you're in, though, you may have a state law inclusion on seclusion or collection law issue arising from just the sheer volume of calls here. But from a TCPA perspective, these cases really aren't surviving motions to dismiss. Next slide. So when we gave this presentation 2 years ago and Facebook had just come out a few months prior, my co-presenter and I were kind of joking that we were worried we were not going to have anything to do because we thought that TCPA litigation was going to basically completely dry up after Facebook. And you know, this chart's interesting to me because we're definitely not at pre-Facebook numbers. But as I think we've mentioned on prior panels, the number of filed TCPA cases has actually gone up about 12% this year over last year. Next slide. So I think what we're starting to see is a bounce back from the immediate aftermath of Facebook when new TCPA cases were down almost 50% from 2020, the year before the case was decided. And this year, the TCPA is really the only consumer protection statute that's up as far as filing numbers compared to last year. And so these cases obviously are still far outpaced by the FCRA, the FDCPA. But where the TCPA becomes dangerous is that 7 in 10, so about 70% of these cases, are filed as putative class actions, which obviously increases litigation risk and exposure. Next slide. Okay, so what's driving this increase? So this past year, I think more than anything, we've seen a significant number of pre-recorded call cases placed to wrong or reassigned numbers. And this seems to be really where plaintiffs' counsel has pivoted after the Facebook decision came down. Now, this is a huge litigation risk because according to the FCC, 35 million phone numbers are reassigned every year, so 100,000 a day. You know, and in that case, there's no prior express consent from the person who you're calling because the called party who now owns that phone number didn't consent for you to call them. So obviously, depending on the facts of any given case, these classes are getting certified. Here's an example of one that was filed against Snap Finance. The class was defined as anyone who received a pre-recorded call from Snap Finance who wasn't a current or former account holder. So that class did get certified in Utah. In that particular case, the named plaintiff told Snap Finance it had the wrong number. She asked them to stop calling her, and the calls and text messages didn't stop. So what ended up happening was that the case settled on a class-wide basis for $5 million. And look, like I get it, unwanted calls are annoying. Nobody wants to receive them. And I think at the risk of sounding too cynical, plaintiffs' counsel took home 1.7 million in fees as part of that settlement. So that's obviously what's driving these cases. So what do you do to avoid this? Number one, and this is the biggest thing, stop calling or texting right away after somebody tells you that you have the wrong number. Add that number to your do not call list, ideally immediately. This is really interesting to me. So the plaintiff's counsel in Snap Finance, he's one of the most, if not the most prolific filers of TCPA claims. His name's Mike Greenwald. I'm sure many of you have seen claims from his law firm. He's actually used coding of wrong numbers to identify class members in other cases. And so it makes me wonder, I don't know if there's a way that you can code wrong numbers more generally so it's not as obvious if you're hit with one of these cases that wrong numbers were called. It seems to help them identify class members. And look, I get that there's probably business reasons for this, but if you can avoid it, please don't use pre-recorded messages in any capacity. It substantially increases the risk of making these calls, including informational and collections calls. By the way, and this seems obvious, but it's been a litigated enough issue to result in a few different decisions. Several courts have held that text messages are not pre-recorded calls. So if you're communicating by text to a set list of customers, you're probably on a much safer TCPA ground than if you're placing a call. And then last, make sure you're using the reassigned number database. So this went live in November 2021. It's a couple years old at this point. And what that is it's a database that tracks all cell phone number reassignments throughout the country. So it's not perfect, but it does provide a safe harbor if you accidentally call a wrong number that the reassigned number database does not indicate has been reassigned. It's definitely a helpful defense in these reassigned number cases. To avoid collecting wrong numbers inadvertently, consider things like multi-factor authentication. If someone's giving you their phone number in connection with an account, think about whether they need to enter it twice if there's a way to do that. There are vendors too who help ferret out wrong numbers if your business needs justify taking those sorts of measures. And I will say too, it's not all doom and gloom with these cases. We still have plenty of defenses that we've had a good deal of success with this year in getting motions to dismiss granted. So if you're using a vendor who, for example, is calling on behalf of multiple parties, there's an argument, depending on the circumstances, that those calls weren't made on your behalf and you're not liable for them under the TCPA. Or if the consumer didn't pick up the phone, courts have held that they can't plausibly allege that a pre-recorded voice was used or played during that call. There's lots of defenses to class certification, so we've got plenty in our toolkit to deal with these claims, even as the number of filed cases continues to rise. Next slide.
This one's me. Revocation of consent cases are actually still an issue. We've seen this illustrated in this Betts versus Synchrony Bank case out of the District of Columbia involving pre-recorded or artificial voice collection calls made to a plaintiff's cell phone, where the plaintiff alleged he had first never given consent and then specifically alleged circumstances where he had expressly revoked consent to be called. The voicemails left for the plaintiff ended by saying, "This is a recording." So the only real issue here was whether the defendant could prove that it had plaintiff's prior express consent to receive pre-recorded or artificial voice calls. The court denied the defendant's motion to dismiss, finding that the issue of express consent is not something that can be dealt with on a 12b6 motion, meaning the case had to go forward. Of course, getting these revocation cases past a motion to dismiss is not ideal, because then litigation costs can start to take off. In May 2023, the FCC issued a new notice of proposed rulemaking, which seeks to clarify and expand a consumer's right to opt out of these calls. The FCC proposes to codify the rule that consumers may revoke TCPA consent through any reasonable means. Of course, this has been the de facto rule since 2015, but it's not actually in the code. So under the proposed rule, consumers could opt out using words like stop, revoke, end, or opt out, and callers may not infringe on that right by designating an exclusive means to revoke consent that precludes the use of any other reasonable method. We have seen case law instances where people have revoked consent by faxing letters to an obscure number and then suing when the calls continue. So on this point, the FCC is looking to balance a consumer's right to revoke consent in an easy way with the caller's ability to process revocation requests. The FCC is proposing that callers that don't believe that consumers have actually used a reasonable method to revoke consent will be afforded an opportunity to rebut the presumption on a case-by-case basis. The commission sought comments on what is unreasonable in these circumstances with respect to a consumer revoking consent, and asked for information about what the industry thought would be sufficient to rebut the presumption. The comment period was closed in August. Some courts have found that contractual consent can't be revoked, and it remains to be seen whether the new proposed rule would alter the case law on that point. The biggest proposed change in the proposed rule is the revocation timetable. Currently, companies must honor opt-out requests either within a reasonable period of time or within 30 days, depending on the type of call. The FCC wants to cut the time frame down to just 24 hours. Many companies already have systems in place that take immediate action once consent is revoked for calls or texts. That being said, we can imagine there are circumstances where acting within 24 hours may be an issue. The proposed rule also addresses a number of consent issues that were raised in pending petitions for declaratory ruling. One of these arises from a petition Capital One filed in 2019, which asked the FCC to allow companies to send a one-time confirmation message to consumers, asking them to clarify exactly what types of texts or calls they would like to stop. The FCC's proposal would allow senders to include a request for clarification in a one-time confirmation message like Capital One asked, so long as the sender stops all robocalls and texts until the consumer affirmatively responds that they want to receive further communications from the sender. If the consumer ignores the one-time confirmation message and does not respond at all, then the sender has to treat that silence as a complete revocation of consent for all calls and texts. With respect to calls made to numbers on a do not call list, and Colleen mentioned this a minute ago, outbound telemarketing calls to numbers that are on the national or state do not call registries are prohibited unless the current owner of the phone number has provided appropriate consent to receive the call, and this prohibition applies to cell phones and to landline numbers. It's important to be mindful about the do not call registries in connection with mixed message calling, such as customer service calls that could have a marketing component. Our key takeaways in the do not call area are to scrub the federal, state, and internal do not call lists. Make sure that you're not calling or texting any numbers on those lists. Also, provide callers with an easy way to opt out and promptly honor all of those opt-out requests. If you're utilizing third-party vendors to make calls on your behalf, ensure you have a process in place where opt-out requests are being shared and honored timely. Also, work with reputable vendors and make sure that your vendor agreements provide adequate protection in this area. Slide, please. Unwanted calls, including robocalls, are the FCC's top consumer complaint annually. So at the end of 2019, Congress passed the Telephone Robocall Abuse Criminal Enforcement and Deterrence Act, known as the TRACE Act, which updates the TCPA. Passage of the TRACE Act demonstrates curbing unwanted calls remains a legislative priority. Under the TCPA, informational calls to cell phones using an artificial or pre-recorded voice require prior express consent, but the same informational calls using artificial or pre-recorded voice made to a residential landline do not. So the rules implementing the TRACE Act, which just went into effect this July, have new requirements that apply to informational calls to residential landlines, made using an artificial or pre-recorded voice without prior express consent. Those calls could include calls related to student loan servicing or collection calls. If you have prior express consent to make informational calls to landlines, then that has not been revoked, you're not going to be subject to these rules. Next slide, please. Under the TRACE Act, if you are making collection or informational calls to a landline without prior express consent, for example, where someone has revoked consent to be called, then these restrictions now apply. You're limited to 3 calls per each month, which really is not a lot if you're dealing with a loan that's in default. You must allow for opt-outs by either providing a telephone number in the pre-recorded message that allows the consumer to register their do not call request in response to that call, or by providing an automated interactive voice or key press activated opt-out mechanism so the called person can be included on the do not call request. And you have to implement company-specific do not call policies and procedures that include creating a written do not call list policy that's available on demand, training your employees on the use of that list, recording and honoring opt-out requests, providing required disclosures during the phone calls, and honoring do not call requests that were made to your affiliates. You're required to maintain records of the do not call requests for 5 years. The TRACED Act emphasizes the importance of honoring do not call requests. And in general, the do not call provisions of the TRACED Act are best practices regardless of whether you have consent. Next slide, please. When the Supreme Court issued its decision in Facebook, narrowly construing the definition of an automatic telephone dialing system, it effectively brought an end to the flood of TCPA lawsuits alleging violations of the statute's restrictions on the calls and texts made with an auto dialer. Just 2 months later, Florida stepped in and responded to the Supreme Court's decision by amending its Telephone Solicitation Act so it operated as its own mini TCPA. The Florida law very broadly and vaguely restricted certain telemarketing calls and texts made to Florida residents and other people in Florida using an automated system for the selection and dialing of telephone numbers. The effect in Florida was a substantial uptick in lawsuits targeting allegedly unwanted telemarketing calls and texts made with an auto dialer. Since then, more states have followed Florida's lead of tightening telemarketing restrictions by amending existing regulations or enacting or proposing their own mini TCPA laws. These states include Arizona, Florida, Georgia, Maryland, Mississippi, Oklahoma, Tennessee, and Washington. Many of these laws are more expansive than what federal law requires, and some have criminal penalties. You should note that each of these state laws apply even when the caller is located outside of the state, but's calling a number within that state's area codes. As more and more states enact new laws or amend existing regulations, companies have to be aware of the potential for liability, not just on the federal level, but also in all these various jurisdictions across the country. Compliance with the TCPA alone is not going to be enough, and we can expect an increase in mini TCPA litigation at the state level. Next slide, please. First, I'll announce the final CLE code of the day is 92564. 92564. Washington and Oklahoma enacted their own mini TCPAs, but they are essentially copycats of Florida's law in its original form. So they're also problematic. Florida, after complaints by businesses and a flood of litigation in May of this year, amended its Telephone Solicitation Act, and it narrowed the categories of equipment that are covered by the statute, and it expanded the definition of a signature to allow acts such as checking a box for purposes of consent, and created a 15-day notice and cure period before a plaintiff can file suit in text message cases. All good news. Those amendments haven't been made to the laws in Washington and Oklahoma. The mini TCPAs are inconsistent with the federal law on other points as well. Some of the mini TCPAs have calling time restrictions that are different from the TCPA, where the TCPA allows calls between 8 a.m. and 9 p.m. Some of the state TCPAs restrict the quiet hours between 8 a.m. and 8 p.m. That would be in Florida and Washington and Oklahoma and Maryland. So it's expanding the TCPA's restrictions by an additional hour. Some of the mini TCPAs also include call frequency limitations that aren't found elsewhere, where the calls are limited to 3 phone calls in a 24-hour period. Others have very specific requirements, like New York's law requires certain disclosures be made at the beginning of each call in a certain order, and Washington's law requires certain time periods, like very specific time periods, where the caller has to identify themselves within 30 seconds of the start of the call. And if the consumer has identified that they would not like to be called, then the call has to end within 10 seconds of them being asked not to call. We're running out of time, but I could go through all of the differences that are all over the map on all of these mini TCPA questions, but state laws, but long story short, we're going to have to keep looking at all of them because the restrictions being put into place are different from the federal law in this area, and we have to make sure that we're complying with all of them. To quickly wrap up, we're confident that TCPA litigation is not going anywhere. Litigation involving pre-recorded and artificial calls is still alive and well. Making these kinds of calls to cell phones still requires prior express consent, and litigation has sort of shifted to do not call and revocation cases, with reassigned number cases also continuing to pop up. And these state laws present significant litigation risks as these states continue to enact more stringent mini TCPAs with a variety of their own specific limitations. I'll turn it back over to Ryan.
I feel like the light's
I'm
going
in
out.
the dark.
Was a sign that this is over, that this is concluded.
I think, yes, everyone has done their duty.
Thanks, everybody. So this concludes today's webinar. Chris is going to put the codes and the survey in the chat. So just keep an eye out for that if you still need those codes. Remember to keep an eye out for a follow-up email, which will include the links to the program materials and a recording of the CLE in case you were so interested that you wanted to see it back again. I don't think that there were any questions that we didn't get to, but if you want to reach out to any of our presenters, feel free to do so, and we can answer any questions offline. So thanks so much for participating, and I hope you all have a great day.